here that this is your day. When the opportunity comes, please use it and speak candidly but respectfully. We have also been able to gather a couple of concerns from our members, and we have come up with a matrix. I don't think that matrix will be able to discuss all of it this morning, but we'll have a member, senior counsel of the bar, represent us when the time comes to sort of deal with the summarized issues that we have been able to come up. They're about 10 or so. As I have indicated, my job this morning is very simple. Welcome you all here, and also take the opportunity to invite the Attorney General to come and share his remarks. Thank you.
This is quite executive. Things are sliding off. I think it's supposed to be a touch screen. My Lord, the Honorable the Chief Justice, the Honorable the Deputy Chief Justice, the Honorable Justices of the Supreme Court present, Honorable Justices of the Court of Appeal, Honorable Judges of the High Court, Chairperson and members of the Judicial Service Commission present, Your Worship the Chief Registrar, the President Uganda Law Society, Senior Counsel present and past President present, the Executive Council of Uganda Law Society, members of Uganda Law Society present and online, members of the Fourth Estate, distinguished guests, ladies and gentlemen, good morning to you all. My Lord, it's with great honor that I stand before you today. Firstly, I must extend my heartfelt gratitude to the members of the bench for recognizing the significance of this forum and sparing time from the demanding schedules to be present here today. I also wish to appreciate the organizers of this forum, the Uganda Law Society, for their diligent efforts in putting this event together and creating a monitoring matrix to track the progress made since the last engagement. In the spirit of inclusivity and collaboration, I wish to emphasize the importance of involving all relevant stakeholders in these discussions. It is imperative that the Office of the DPP, who are present here today, the Judicial Service Commission, who are here present today, and other key entities are actively engaged in such fora. And we thank the Judiciary and the Law Society for ensuring that the feedback from the last meeting has now come to pass. It is through a comprehensive and roundtable approach that we effectively address the challenges facing our justice system and devise strategies for improvement. I'll be remiss if I do not commend the government of Uganda and the judiciary for their efforts in addressing the issues raised during the last bar bench forum, which was held last year in May 2023. For example, the challenge of understaffing in the judiciary was prevalent across many court divisions and was constantly raised as a major cause of case backlog. We are pleased to recognize that significant strides have been made, including the enactment of the Judiciary Amendment Bill, which has resulted in a move to increase the justices of the Court of Appeal from 15 to 35. This is in addition to the recent deployments of new magistrates and registrars and the Public Service Commission appointment of state attorneys under the Office of the Directorate of Public Prosecution and the Attorney General's chambers. Today, I urge each one of you present physically or joining us online to candidly share your grievances or challenges that you have encountered. Rest assured your voice will not fall on deaf ears. Together we will endeavor to find practical solutions to these issues to ensure a more robust and responsive justice system. To the advocates present here today, I would like to emphasize the issue of professional conduct. Reports of misconduct of lawyers and allegations of involvement in fraudulent activities continues to arise. It is high time that we challenge this narrative and diligently serve our communities. I call upon every advocate to reflect on his or her fundamental responsibility as an officer of court, the duty to serve the public and the obligation to uphold the integrity of the legal profession, both the bar and the bench. The legal profession is a noble one that requires the utmost integrity to maintain the public trust. Moving forward, I propose that we convene these engagements on a quarterly basis or in a more regular basis to have this feedback. My Lord, the Chief Justice and honorable members present here, the storm in this place is clear. The issues that are going on are clear. Independence of the judiciary is high on everyone's agenda, so they say. No doubt we all want to have an independent judiciary. But an independent judiciary is independence in judicial decision-making process. It is not independent of Uganda. And it has to be very clear about this. So, when we are dealing with independence of the judiciary, we must remember that the judiciary, the executive, and the legislature will continue to communicate on matters affecting the different arms of government as amongst themselves and as between themselves. On the issue of discipline and handling matters, honorable colleagues, especially members of the bar, I want us to remember these few questions that I'm going to leave with you. How do we raise concerns? How? Do we shout? Do we write? I don't know, there is no English word for it. We call it Chirochitwa Robonaku in Luganda. How do we raise our concerns? Where do we raise these concerns? What is the correct fora to do it? When do we raise these concerns? What is the concern? Even the issue of putting together what the concern is important, so that we all understand what your concern is and leaves nothing to our imagination. I am the head of the bar, I am a member of the executive, so I serve both sides of this coin. So at times I see these letters and I wonder, what is the issue? So we need to be clear as to what the issue is, even as we deliberate here today. If you want to say that there is corruption, I would like us to say Judicial Officer X on 12th June this date took money or did this. That is the issue. So, and then also, why do we raise the issue? We raise the issue, obviously, for all right-thinking and good-thinking members of society for the development of our country. So we need to have those. I leave those questions to you. I have made comments about the letter between the judiciary and the executive generally, but I have another issue that has been raised in another letter, again from members of the bar. And some of them are named as senior members of the bar, whom I would imagine would be the ones actually telling me as the Attorney General, because I'm even younger in practice to them, on guiding me on how to do certain things, writing how can the Attorney General direct the judiciary. The Attorney General cannot direct the judiciary. But the judiciary is the client of the Attorney General. We need to be clear about that. The judiciary is my client as the Attorney General. And I am entitled to advise the judiciary. And I will continue to advise the judiciary. I dare not direct the judiciary. And the Constitution, even the choice of words, is clear. It shows the Attorney General will be the principal legal advisor. So when I write these letters, first of all, yes, I did write the letter of the Chief Justice. That is correct. If a person had come to ask me, I would have answered that likely. I do not think I breached any law. But I would have imagined that if a member of the bar finds that the Attorney General has rendered an opinion which is wrong, it is incumbent on each one of you as a member of the bar, because when I write that opinion, I write it as the head of the bar. It is incumbent upon you to come and say to the Attorney General that, Attorney General, you have rendered an opinion which is wrong in this aspect, because I am not by any chance the custodian of all the laws in my head. I am going to make mistakes. But if I make them, I would appreciate it if lawyers came and said, Attorney General, you rendered an opinion which was wrong to this extent, and I will correct it. But to write and say the Attorney General has advised the judiciary and therefore has impeded the independence of the judiciary, that I will not accept. Maybe you might challenge me on the English I use, but if you want to challenge me on the law, let's discuss that as lawyers. And it is for the benefit of all of us when you point out that a mistake has been made on a point of law, so that we correct that record. But to say that the Attorney General cannot write, that is not correct. And I do not appreciate it. I take great exception to that. They signed the letter, they know themselves, the senior lawyers and junior lawyers. No, that's not how we work. Lastly, boycott. This is a trade unionist approach. Trade unions that boycott because you may boycott, and as you see, life continues. And you see the numbers start reducing because people start having conversations from 18 to 12 to 8 to 5, and then you end up alone. Boycott is not a good method of practice of law. Argument and discourse is our trade. We lawyers don't boycott. We argue our way through any situation. So I'm calling upon those who have written to boycott this forum. I sincerely hope, and I thank the President Law Society for having put it online. I sincerely hope that they can get online and raise their issues, or at least listen to what is going on here, so that we can participate in this process. So I want to encourage you colleagues. I respect their decision. I don't agree. I think the best way for us to deal with matters as lawyers is to argue our way out. In conclusion, I thank all of you for unwavering dedication to the cause of justice. The Office of the Attorney General and myself, indeed, I stand ready to offer the assistance in any area within our mandate that shall be raised during this forum and anywhere else. Colleagues, people call me and ask me questions, and we deal with them. People say, in fact, I thank those who call me and say, Attorney General, we made a mistake here. And I've asked why. And you've seen me recording opinions from some of you. I've written an opinion, someone renders me advice that I was wrong, and I've recalled them. I cannot I cannot let an opinion stay there when it is wrong because I'm Attorney General and I'm shy to say I made a mistake. No. If I have rendered an opinion which is wrong, come, let's discuss. I'll withdraw it if it is wrong, but you must convince me with the law. We are open to dialogue, implementing the necessary reforms and taking proactive measures to enhance the efficiency and effectiveness of our legal system. Together, let us continue to work collaboratively towards the legal system that serves the interests of all Ugandans and upholds the rule of law and indeed the independence of the judiciary. Thank you for listening to me, and I wish you a very fruitful conference today. I say all this for God and my country. I thank you. Sorry. I need coaching all the time. And now it is my singular and profound honor to invite you, the Honorable the Chief Justice, to come and make your remarks to this conference. I thank you.
This one does not hold up.
Thank you, learned Attorney General. My Lord the Deputy Chief Justice, the learned Attorney General, head of the professional legal bar, that is meant to say there are other bars. My lords, justices and judges of the Ugandan courts of judicature, Your Worship, and other members of the Ugandan courts of judicature, Senior Counsel President of the Ugandan Law Society, other senior counsel who have served and left office for you, my colleagues, members of the Ugandan Law Society, ladies and gentlemen. Let me say from the outset, I am pleased that today we converge here to converse among ourselves. I am more particularly pleased because when I look back, arguably the most profitable, the most meaningful part of my professional life, the one in which I professionally grew and matured, was when I was a practitioner, when I was like what many of you are now today. Those are several years ago. And the benefit of that practice still informs the little output that I make in deciding judicial matters. So when I meet you, whether we agree or we do not agree, at least we can agree to disagree if it comes to that. You know that I meet you as a colleague, not as the head of the judiciary. I meet you as someone to whom you can speak freely. There's no barrier, there's no wedge between you and me, because I hold the legal profession in very high esteem. I did my part, the record is there, and as a matter of fact, it was because of the ethical practice that I was known for. It was my commitment to helping justice seekers access justice that I was made a judge. It was because of my contribution to the legal profession that I was made a judge without being interviewed, because I'd already been interviewed when I performed as a private legal practitioner. When Justice Seth Manyindo looked for me, I was not even in the country. I was in Juba pursuing the peace talks between the government of Uganda and the then Lord's Resistance Movement / Army. He interviewed me with these members of the Judicial Service Commission in my absence without me knowing I was being interviewed. There was no contact, verbal or physical. And I came to know about it when I came to the country for 1 week. And he said, I've been looking for you. Indeed, he had been looking for me. I've sent your name and 11 other Ugandans for you to be appointed High Court judge. So my first question was, I've not been interviewed, I didn't even know. He answered, who did you practice before? Didn't you practice before me? As a matter of fact, I was even toying with the idea of either sending you to the Supreme Court or the Court of Appeal, but I realized I would be doing injustice to you if I did that. One, you had veered off into politics So I thought maybe you've rusted a little and you needed to polish and come back to where you were. And secondly, if you've never been a trial judge, there is something which will always be lacking and you could cause injustice. You are more complete if you've been a trial judge. It doesn't matter. You can be a trial judge for 1 day, for 2 days, and you can then go up. Indeed, I went up after being a trial judge for 3 years. So I want you to know, and the other thing is, I was enrolled in May 1985. Some of you may not have been born. And I practiced law for 23 years before I was appointed judge. And by the grace of God, I was not just in what you call, I always call it the fourth arm of government, the area of public opinion, the private sector. I've been favored to have served in all the 3 arms of government plus the fourth. The fourth one is the one I've just told you about. The other one is the judiciary, where by the grace of God, again, I'm privileged to head, and that's why I'm standing here. Then one of those rare opportunities was one of the hundreds of Ugandans who framed the 1995 Constitution. And then I was elected as a member of parliament. I served in the 6th parliament, arguably one of the best in the post-1995 Constitution era. So I speak with a wealth of experience on many of these things in the various arms of government. I have seen it, I have played in them, and my record is there to speak for me or to speak against me. So when I was enrolled in May, I think 23rd of May, the Chief Justice then was George Masika. He's still alive, he's there in Bale. For those of you who come from Bale. I remember what he told us. Say, you've been enrolled, it's a huge responsibility. There are people out seeking justice. I'm paraphrasing what he said. There are people there seeking justice. But as an advocate, when you come to court, when you appear in court on behalf of other people, it is not your case, it is their case. Yours is to ensure that justice is done. And remember always, and I hope I can impart this to my younger brothers and sisters in the profession. First and foremost, your primary responsibility in court is an officer of the court, not as a lawyer for A or a lawyer for B. That is secondary. It is in fact because you are an officer of the court that you are certified, and it is the court that certifies. Every year it is the chief registrar who issues you with a certificate, not with a trading license. You're not traders, you do not deal in commodities. You provide services, professional services. It's a great honor for each one of you, for all of us, to be able to provide professional service to justice seekers. So first and foremost, you are an officer of the court. Your first duty is to the court, to see that justice is done. And our training was, because of that, I might be on this side and my younger brother is on the other side, as we used to do with the late Henry Kayondo and Katera Jonathan. For Henry Kayondo, we would carry his file, because the law is, if you're senior counsel, as he was, you cannot appear alone in court. I hope that is still the law. You must have an assistant. So we'd find him down. He was a very stubborn fellow. We'd find him down, he's parked his vehicle, he's carrying his file. And you say, no, sir, you cannot. Oh, my son. Then you carry his file, you go to either the court or the chambers of the judge, you put his file on the desk, and it turns out he is on the other side of the matter, you're on this side. Then you fight him tooth and nail after honoring him. That was the decency. That's the decorum with which we held the profession. You then fight him, and then when you're going out, you carry his file and take it to the vehicle. I don't know how many of you do this. The other one is, and if you've not done it, and if you cannot do it, then the circuit in your professional career is not complete. How many of you know of a decision, whether Ugandan or whether it is only persuasive because it is from outside, that argues against his case and brings it to the attention of counsel on the other side? How many of you have done that? For me, in my practice in 23 years, only 2 lawyers did that to me. Jonathan Katera, who is now dead, and Cosma Kateba, who is still alive. Those days, there were no this social media thing. He would call you on a landline. Are you aware of this case? You may find it interesting because he's already ready to distinguish it, but he has brought it to your attention. How many of you do this for the love of the profession? But if you consider yourself a trader, no, there is no way you can do something that seeks to reduce the beauty of your commodity, the beauty of your merchandise. So that is the profession I practice in. In that profession, let me tell you, my younger brothers and sisters, for us, judges were demigods. Judges were demigods. You're walking on the corridor, going to another court, a judge comes. You stand aside. You don't begin, my lord, good morning. No, we wouldn't do that. If the judge does not speak to you, for you to stand and bow down in respect. The situation even more serene when you are in court. A judge is there presiding, and they are different temperaments. Those of you old enough to have appeared before Justice Ouma, you know what I'm talking about. You would think he was a very bad person, but that's how people are treated. But he would never, that temperament would not be in his judgments. His judgment would be totally the antithesis of the person who would treat you really and say, what have I done to this judge? And there was no seniority or juniorship in the manner he would deal. He once dealt with my boss, the late Obolo Chola, who was his classmate in Dar es Salaam. Then later he called Obolo Chola and said, why were you misbehaving in my court? Anyhow, I'm just giving you tidbits that the Law Society, it is what we make it to be. We can either choose the Law Society to be that admirable, that respectable, that sought after landed profession, or as the Attorney General said, we can decide to be trade unionist. Choice is yours. You can decide to be trade unionist over whatever matter. And with the world of social media, there is so much material, fourth industrial revolution. There's so much material out there, so much. But you have to sieve, you have to remove the seed from the chaff. You have to understand, if we were to move with social media, we would never, actually, you cannot govern the country, you cannot ensure the rule of law. Among yourself would be fighting, friendly fire and that. And friendly fire kills, by the way, whether it is between the judiciary and law society, or within the law society, or within the judiciary. All those are friendly fire. But who told you that a gun fired by a friend does not kill you? The bullet is not your friend. The person who pulls the trigger might be your friend. So all these things you have to keep in mind. We really have to keep in mind. But I want to thank the President of Uganda Law Society for initiating and making this possible. And with the benefit of hindsight, this is what we should have been doing annually a minimum of twice annually. So much of these other things you hear, they're supposed to be big issues even when they're non-issues. Some of them are really petty. Some of them we would discuss, for those who take beers at a reception, with a bottle of beer in your hand, and the matter ends there. Actually, great decisions the world over are made under not in this formal setting, just made with a glass of wine in the hand. Very great decisions that transform the world. Whether it is the New World Order, they are never made in these conference halls. At times, the conference hall brings this attitude. And then when you relax outside, say, what was the point you're making? I have seen it. I was State Minister for Foreign Affairs, International Relations. So I learned a lot. The world of diplomacy, it is not this gathering. It is just one-to-one. So many senior counsel here. I thought I saw Andrew Kasiri on the screen. Where is Andrew? Yes, Andrew is here. So we grew up with him at Budo. Ben Makerere, then practice. Then he is still interested in making money. For me, I say, come and see where the beauty of legal practice in the judiciary. He has not come. So tell me, why shouldn't Andrew walk over without an appointment and say, don't call me even Chief Justice, now Oweni Dolo, as we used to call him, and I say, okay, Andrea, what is it? Say, what is this I'm seeing? What is this I'm hearing? How can you do this? Because if your friend tells you this is wrong, you'll think about it. If the person who you perceive or you know is your enemy comes and tells you, this is because you have Nugu. So within, if senior counsel comes, doesn't have to be Andrea, it can be JM, Mary. He was my roommate at the university. Yes, and classmate as well. So we don't even need to discuss these things here, my brothers and sisters. We only need to know. If Windolo appears to be unapproachable, the man, when you look at him, you think he can swallow you, assuming I give that perception. There must be somebody there whom you can say, go and talk to your friend. It is not possible that any human being does not have one person who can approach him. If I think the president of Uganda Law Society is very difficult, I'll say, who is his friend? Then he goes and approach him. I'm glad Professor Sempegwa is here. When there was a spat in the Supreme Court, he took the lead, came over to me with a team, and we had very useful conversation and started a process. I don't know whether it has ended or whether it ends or not, but the fact that somebody, some senior person in the profession, says this is not good for all of us, let's do something. If I had not said, probably many of you would not know that process was underway. You will not know that process, whether it concludes positively or not, did a lot to calm the storm. Because we spoke. When you're given the opportunity to speak, you feel that the fish bone stuck in your throat is removed. So for me, for you as officers of the court, please, and we'll continue issuing you with certificates, not trading licenses, and value the fact that yours is a certificate. It's not given by Kampala City Council, it's not given by Kamuli District, it's given by the Chief Registrar to certify you annually that following your conduct last calendar year, you still qualify to continue serving people, justice seekers. That's all about it. And if we do that, oh no, we make for a strong judiciary, we make for a strong law society, and we make for a robust protection of democracy, the rule of law, name it, because we act together. Acting together doesn't mean I compromise my position. It only means I benefit. Whenever I make decisions, those decisions are informed. That's how I understand. Now, I will say a lot more when I hear from you, but there are certain areas that have come out. Independence of the judiciary. I hate the judiciary. I hate the judiciary with the team. My Lord, the Deputy Chief Justice, Justice Richard Butera is here. He was a tutorial assistant in Makerere when I was a student. I think it helped us to understand commercial law too, if I recall. He's my Deputy Chief Justice. I work with him. The fact that he taught me, I respect him. I am sure when you go home and you meet your primary school teacher, it's different. You'll call him sir. He's also calling you sir, but you say sir. You see? It's like in the military. The person who instructed you those 9 months, in your mind, remains superior. You can be field marshal, you can be commander-in-chief, but that person, you respect. So my team, I have the Deputy Chief Justice, I have the Principal Judge, I have the Chief Registrar, I have the PS, who is non-judicial officer. We run the judiciary together. It is not possible that out of these 5 of us, none of us can be approached if there is any issue. It is unthinkable. If that is what we are, then we have to go back to the drawing board, call an induction course where really we have got to be inducted on how to administer an institution. Independence of the judiciary. The Attorney General spoke about it here. What is independence? Independence of the judiciary, which has meaning when you treat the individual judicial officers, is with regard to my judicial decision making. That is my reading of the Constitution, both literally and beyond the literal meaning. That's what it is. It doesn't mean the judiciary or parliament or the executive is out there. They can only speak to one another when they've turned their back to one another. That's not this is not my reading of the constitutional provision with regard to independence. There must be harmony. I once gave this example, and somebody in his wisdom decided to report half of what I said. The framers of the 1995 Constitution, and this is in many constitutions of the world, provided for a presidential democracy, a presidential type of governance, where the president is elected. It is not the winning party. It is actually possible that along the way, a president is elected and his party forms the opposition in parliament, because he would be having less members of parliament than another party whose presidential candidate will not succeed. It is quite possible. But while we do our work, the Constitution says that the president has a hand in all the 3 arms of government. It's not my concoction. If you've not read it, then I have fears. The obvious one is he's head of the chief executive, head of government, head of the executive arm of government, heads cabinet, where policy is made, where decisions are made to be taken to parliament and that type of thing, where many laws are generated from. Then parliament sits, discusses, nobody dictates to them what the outcome of a bill should be. That is their purview. They come up with it, whether good or bad, but then the decision of parliament is not the end of the matter. The bill is sent to the president to assent. Now, when the president assents to a bill and makes it and turns it into law, Is that interference with the independence of parliament? Is that interference with another arm of government? Then, even within the justice, with judicial decisions, the same constitution actually makes the president, and get me right, the last court of appeal with regard to sentence. Civil matters, there's no way you can intervene. But with regard to sentence, you can appeal on issue of the punishment. You're convicted, you're sentenced to custodial term, and the president, he does it prior to every huge day. You hear 900 people have been released. Rwakasisi was released. Who else was released? I don't know. There are many. That is in the exercise of his prerogative power on a judicial function. He will not overturn the conviction. He has no such power. But where the courts of law feel so strongly, this man committed this murder, or in the act of terrorism, this was devastating, you must serve life. You must suffer law in accordance with the law. You must suffer death in accordance with the law. Excuse me, I have a bad flu, but this is so important, I had to come. Now, when the president overturns the sentence, instead of someone suffering death, instead of someone suffering custodial punishment for the rest of their lives, or for 20 years, or for 30 years, said, okay, I've pardoned you, you go home. Is that interference with the independence of the judiciary? And then, every so often, the president engages with the Chief Justice. What you're talking about is just the tip of the iceberg. Engages. And many times it is at the instance of the Chief Justice. And the law says, with regard to budget, I don't present my budget to the Minister of Finance like other people do. The judiciary's budget is handed to the president, and the law says the president does not change even a punctuation in our presentation. He presents it to Parliament as we have put it. That is the law. But as head of the executive, he knows what the basket is. He sends it with a separate document, his comments. As head of finance, we have this problem, we think this is not affordable, whatever is affordable is okay, and then he presents this to the Speaker of Parliament as it is. So is that interference? Now, the President writes to the Chief Justice. I will not, excuse me. I do not have issues. I'm not joining issues with you on your concern. Being concerned is the right thing to do. And for me, each one of you, the judiciary I head, and for the duration when the judiciary is under my charge, take it from me, I would be very disappointed if you cannot criticize the Chief Justice, if you cannot criticize the management or the administration of the judiciary, when you know your criticism would help make for a better administration and for a better country, upholding the rule of law, ensuring that our people enjoy the fruits of the constitutional provision of the judiciary. But Here we are. I make a decision. And when I am going to make a decision, you, hiding under the guise of your clients, come with, how do they call them, these people with biceps, which, kanyamas, the notorious word is kanyamas. Literally bringing kanyamas in court. Really? So, bringing kanyamas in court, or I've made a decision, and you buy a whole page in a newspaper purporting to attack a judgment of the court, say it should be impeached, should struck off the record. Did you attend law school? Really, did you attend law school? Maybe the president who writes to the Chief Justice and then he says, I request you to do this. We can forgive him because he could have used the other method of finding out from the Chief Justice. My people are complaining about this. Please attend to this. And it stops there. But how about you, member of the legal profession? A profession I've been proud, I'm proud to have been a member of. You take issues with a judge because he or she has decided against you. You take issues with the judge, even make derogatory, make reference to his genitals. You are aware of this. What high moral authority do you have to criticize a presidential letter which tells the Chief Justice, I request you? Does not say you must, does not say I order you, say I request you. A letter which any citizen could have written, because the president is a citizen. I mean, he's a citizen, yes. He has every right to express concern, as long as he does not dictate to me what to do. So what moral high ground would you have to attack the president? Me, I had high moral ground to attack the prime minister. And we made peace. We now we know our lane, she knows her lane, and we are great friends on account of this. We work together, we consult. When she took over the chair of the judicial officer and began lecturing to the judicial officers for the decision they made, I was very clear that I could not fathom, I could not stomach. But I forgave her because she's a lay person. How about a member of the learned profession saying the reason a judge has made the decision, there could be some deficiency in his genital? Really, from My question is, we have senior person in the profession. What did you do when this came out? What did you do? Jesus says, why do you get concerned with the speck in your neighbor's eye when you have a whole log? That places a log in the eye of the legal profession, which I'm proud to be a member of, which I used to practice in. Where is the high moral ground? Then the principal judge exercises his administrative powers, constitutional powers, over issues you are raising here, and you are rightly raising them. You have 200 cases. This is not right. Please leave everything else. Do not take on new cases until you resolve this. And then, where do we hear complaint from? From the Law Society of Uganda. With the left hand, you are saying judgments are delaying. With the right hand, you are crucifying the principal judge of Uganda who heads that court for saying, no, please. Justice is not in hearing the cases. That is only half the story. You must deliver. Where is the problem? How do we resolve this? And before these things go to social media and what have you, why shouldn't the president of Uganda Law Society come? Why shouldn't the senior counsel? I gave you the example of Professor Sempegwa. Why shouldn't you walk over to the principal judge? We hear this. And then you understand, many times Many times we jump into things because we have not sought to understand. Even now, when we understand, the damage is done. The damage is done. So my appeal to you, please, let me speak for myself first. Criticize me as much as you can. You can walk over to me. You can write to me. If I've become too notorious, you can now go to media, not this social media thing. Buy a page, and then I will also buy a page and respond to you. That is how things are done. That's how things are done. What other things? There are many of these things which we would have discussed if we had this type of forum, if we had thought of it. That's why I thank your president that we've come to this. Then I hear about the Balalo thing. One of you said his duty is, I read in social media, but why I don't take it seriously, because social media is capable of anything. My responsibility is to quarrel in court. You will not quarrel in my court because I'll chase you out. You come and argue your case, that's not a quarrel. You come to my court as an officer of the court, you open my eye. You enable me see issues using the lens you have. Then I adopt your lens if I agree with you. You don't come to quarrel. Quarreling is for the marketplace. The legal profession is not a marketplace. I told you before, you're not a commodity dealer. You don't deal in merchandise. My question to all of you, whoever said the Chief Justice made any remark about the Balalo? Where is the source of your information? You read Ufono Pondo, whoever has brokered him to write what he has written, and you make it an issue of Uganda Law Society. Really? How do I respond to somebody whose business is to act for others for a bottle of crude waragi? I mean, how do I respond to that? Yeah? What pains me is that a member of the learned profession says this is an issue. The Chief Justice was involved in the Balalo thing. When? If you sought, if you're really concerned when you hear something alarming, and you sent a team, we are reading about this, Mr. Chief Justice, I would. Probably you would buy 10 pages to hail me, to thank me for whatever I've done, not about the Balalo issue. To avert a possible insurgency in northern Uganda. Who says a Chief Justice cannot be involved in peace building? Who says? Where in Bangalore, the Bangalore Declaration, does it say the Chief Justice must sit in his chambers only? Where? If I can make peace between two parties, why shouldn't I make peace between millions of people? As long as it does not compromise my office. So these things, we would serve one another a lot better if we seek. Somehow, I think it's like there was a distance between the judiciary head and members of the Law Society. Or some people have got ulterior motive, I don't know. Because it doesn't make sense to me. Because we are now behaving like secondary, in all secondary schools, senior 2 students are normally the worst because they were tortured in year 1 and they want to. My appeal is let Uganda Law Society not behave like secondary school students. There are so many, again I speak for myself, I am so accessible. It is known you don't need an appointment to see me. These people know in this country. The only thing is to know when I'm in. Many of you have come, walked over. Oh, council called, some of them I know, some of them I've never heard of. Council so-and-so has come, wants to see you. I leave what I'm doing and I see them. That's how it is. So then, you start and I'm supposed to respond, the Balalo issue, the Chief Justice. It means you don't live in this country. The Balalo issue is a presidential issue. The president issued an executive order, and if you've never heard of an executive order, look up the Constitution. In May 2023, The execution of that executive order was delayed by an opinion. And that delay was going to cause a lot of problem in the area. And the president of the country asked me, please intervene in this. Otherwise, if I leave it to politicians, the situation can go bad. And that was my role. And the matter is being resolved without bloodshed. And here's somebody saying Balalu issue, Balalu issue. There is no Balalu issue in northern Uganda. If you care to study, the issue is not Balalu. The issue is different. And that was our finding. Then one of you says, my duty is to quarrel. Why don't you come over to the Chief Justice home or chambers and quarrel with him over the Balalu issue? He has his tongue. You know, for him, the Chief Justice I know, the one called Owindolo, you speak with a foul mouth to you, he will respond with a foul mouth. This thing of saying a judicial officer must suffer quietly, that one Mr. Owindolo will never do. I tell you as it is, the difference between Mr. Owindolo and maybe many other people, we can cross fire today, and by the time of sunset, for me, the thing is behind me. It's done. I want you to hear my view. You've heard my view. It is done. I don't hold grudges. And that's why my pressure is good. Even at the age of 68, my pressure is never gone beyond 130. Not 68. Because I don't allow these things to dwell in my mind. I respond to you. Either we agree or we don't agree. By the end of the day, it is gone. My other policy, and I've told my judicial officers, even when somebody had made such reference to you as abused in public, you took oath not to be intimidated, not to make decisions out of fear or intimidation. You took oath not to favor anyone, but make your decision in accordance with the law and your understanding of the evidence before you. You took oath not to be persuaded by your affection for any of the parties. And the fact that somebody abused you only the other day should never Is that sabotage? Can this It's back now. I think it was some sabotage, but the joint forces of the judiciary and the law society, they reorganized themselves and the enemy has been pushed back. The fact that you've abused me, the fact that you acted funny, the fact that you acted totally, absolutely unprofessionally, will never influence my decision. Whether you are a lawyer for someone, I'll never visit your folly on anybody. Or if you are a party, and I really pray that such people come before me, then you'll know that the only way I can make you realize that you're acting on a folly is to render justice in accordance with my oath. That I will always do. But if you wrongfully attack me, I will respond. So many people have said, no, you're Chief Justice. Yes, who doesn't know I'm Chief Justice? There is nowhere it is written that a Chief Justice must be dragged in the mud when he can stand up and refuse to be dragged in the mud. Yeah. So that one, I'll make no pretense. But constructive criticism. I will even write back to say, thank you so much, but I disagree with you. I'll say, I disagree with you. If I agree with you, I'll say, oh, that was a good one, I agree with you. The way we deal with your submissions. Then finally, I think I've talked for much longer than what I should, but I consider it important. We have delayed judgments in our courts. It's not a new thing. It's only that now we are more conscious. We are now, the world has exposed a lot of things. We've made our reports, new law year, the annual accountability. I think the last one we did was October or thereabout. Annual Judges Conference, we normally give. Because of the transformation we brought in the judiciary under my charge, where we fought and had the judiciary budget nearly doubled. For the first time, I think, maybe since the judiciary of Uganda was established, that this happened. We've been able, because the policy we've come up with, how can we afford, and for me, that is the signature. I want it to be my signature thing in the judiciary. How can we afford our people meaningful access to justice? Every constituency, county constituency, must have a magistrate grade 1. Every district, now there are 140 or 150 districts, must have a chief magistrate. Then a cluster of districts must have a high court. There used to be 20 high court circuits. I have gazetted 38 now. There are now a total of 38 circuits, which will enable your, okay, first of all, that is your marketplace. So you should be the first people to applaud that, yes, the legal institutions are churning out lawyers and there's no employment. Now you can appear in a village deep in Toro, village deep in Busoga, or in Lango, West Nile, or here in Buganda, because there'll be a court manned by grade 1 and the district by chief magistrates. And indeed, we have used the enhancement of the budget. We've started from down. We could recruit 90 magistrates grade 1, where we used to recruit 12 or 10. In the past, if we recruited 16, we would celebrate that this time we recruited 16 G1s. Now we are recruiting 100, 80, 90. The chief, you are the ones who practice. The chief magistrate of Fort Portal used to look after 3 other magisterial areas. The one of Soroti, same. The one of Gulu, same. The one of Lira, So we jumped from 40-something chief magistrate. We are now, I think, 82 or 80-something. How many? 92 chief magistrates. Meaning now, a chief magistrate does not spend 70% of the time on the road going to the other magistrate areas. It also means the number of files now reduced because they are distributed. Where a chief magistrate had files up to the ceiling, now the file is this high. So when you see our returns, the greatest success are in the magisterial areas, where the turnover is huge, so impressive. But I still have problems in the High Court. Because per capita, the number of judges I have, per capita, you cannot make that impact. And by the way, and I believe my young brothers and sisters, you know this, judicial officers work so hard. Weekends, if you visit offices, chambers, more often than not, you'll find judicial officers in their chambers doing work. You don't find it with other departments of the state. They really work so hard, but the volume of work. And I think the other area is we are to blame. We spend all the time hearing cases Monday to Friday, and that has a negative effect on judgment writing, because you need to rest also. We will discuss with judicial officers, maybe they should hear cases 3 days a week. and set 2 days where they would be writing judgments and handling any urgent matter that is really urgent. Maybe that, because it is in delivering judgments that will be seen to have rendered justice. And then, and this I've spoken about, there is the danger of the courts of judiciary becoming courts of statistics instead of courts of justice. We need to weigh that. I can churn out thousands of cases, but what is the value of these judgments or decisions? But I could also churn out only 300 instead of 1,000 or 2,000. And they really resolve the matter and everybody is satisfied. So we need to debate that. So where the Ugandan Law Society can help us, where I don't see you, make noise for us about the budget. Make noise. Instead of killing the victim, you deal with the person who can make the victim perform. Because we are victims. I've not heard you standing up and telling government, that is the other arm of government, telling parliament, you do the appropriation, our people are suffering. So that we act together, we act in concert, and if there is enhancement, I can be able to recruit 20 judges of the High Court annually. There will be a big difference. Then finally, the Supreme Court. The worst performing court is the Supreme Court, and in case you've forgotten, the court is headed by the Chief Justice. So before you skin the Chief Justice from the back, listen. Some month in 2021, the chambers of the Chief Justice got banned. That day, I had scheduled a meeting at 10 o'clock in that very chamber. But because I had another meeting that would come in the High Court and the other things, where the head office of the judiciary is, I decided that the other people should be informed to now come to the High Court, and I attend to them. Again, that was God's hand. Where the AC, the panel, which exploded, just behind me, my printer, which was my right hand, where I would touch like this, got burnt. The glass on my desk got burnt and that type of thing. But God thought I still had something to do, including speaking with you today. So God said, no, you still have to speak to the members of Ugandan Law Society. You will not die today. So I was not there. And immediately the technical team went, inspected the building and said, the building should not have been occupied in the first place. The court should not have occupied the building in the first place. So we were homeless until last year, 2023. You don't know the difficulty of being homeless. But that notwithstanding, we did everything possible to be able to do something. We concentrated in doing matters which required individual justice. There's no way we could say, my brother, the chair of Judicial Service Commission, understands my predicament, because his building was also condemned, and for him he could hold his sittings in a hotel. I'm not sure if you people would have permitted me to rent hotel rooms and conduct a court hearing. You would be at war with me. So we had that problem, and I have judgments, about 3, which I generated, drafts. In the process, 2 of the members retired. Then before we could reconstitute, 2 passed on. I have to reconstitute now that I have new justices. Now that I can hold a constitutional court sitting from April, I should be able to hold a constitutional sitting, because I would like my 2 sisters from the Court of Appeal not to leave any matter behind, to be reconstituted. They complete what was before them, and I know that beginning 2nd of May, 2nd of April, we should be able to start work with a full court. So that's part of the delay. So we started work sometime last year as the Supreme Court, premises where we are squatters, and we are about to relocate now to our new building. The first time the appellate courts in Uganda, since 1967, when the Court of Appeal of Uganda was created, the first time for the appellate courts to have a home is the one we are relocating to. So I'm appealing to my brothers and sisters. Yes, nobody wants to delay judgments. Nobody. I mean, I speak for myself. I enjoyed appearing before judges, and I told you the benefit of my appearing before judges. I enjoy judgment writing. When I sit to write a judgment, I really enjoy. But we have these difficulties. And many of these things, you will not even raise them if we had this interface, if we had this professional intercourse within us. That, how do we do this? Again, a glass of wine, I'll be taking my juice, which looks like wine. You take your crude things. For me, I'll be taking my juice. That's, I think, the way to go. Thank you for listening to me. Thank you for affording me the opportunity to speak with members of a society I'm proud to be a member of. May God bless.
Distinguished attendants, perhaps we can give the Honorable the Chief Justice another round of applause. My Lord the Chief Justice, perhaps I can invite both you and the Honorable the Attorney General, the head of the bar, to come up and sit up here as we move to our next session, an engagement with the bar by way of a plenary session, and the President of the Law Society. If the President of the Law Society could, yes, escort them to the podium. As the Honorable the Chief Justice, the Attorney General, and the President come up to the podium, permit me to recognize amidst us the following people. May I recognize my Lords, the Justices of the Supreme Court of Uganda, His Lordship Mike Chibita, as well as my Lord Justice Madrama. I would also like to recognize the judges of the Court of Appeal of Uganda, my Lord Justice Kiriawire, present with us. Permit me as well to recognize the chairperson of the Judicial Service Commission, Justice Benjamin Kabito, and the commissioners present, Mrs. Ruth Sabatindira, Senior Counsel, and Mrs. Nora Winnie, Senior Counsel. Permit me to recognize also the heads of the divisions of our courts of the High Courts of Uganda, the Civil Division, represented here by Justice Musa Sekana. I also recognize the head of the Criminal Division, Justice Elubu. I also recognize the head of the Commercial Court. I believe he has left. I also recognize Justice David, who is present here. I recognize the heads of the Family Division. I'm not sure whether they were the representatives present. May I also recognize the head of the Industrial Court, Justice Mugisha. May I recognize, perhaps I should also mention that my Lord Justice Chibita is the chairperson of the Judicial Training Institute. So it's now my duty to recognize the executive director of the Judicial Training Institute, Justice Damali Mlwanga. May I recognize as well the Assistant Director of Public Prosecutions, Mrs. Winifred Ahimbisibe. May I also recognize Mrs. Doris Akidi from the Uganda Law Reform Commission. Senior counsel present, perhaps you can all stand up for recognition, headed by Professor Sempebwa, who is present. I also did recognize very many distinguished colleagues from the bar, senior lawyers from the bar present. You're all welcome. And my Lord, we have over 1,000 people online. And all of you online, we recognize you in your respective capacities. Thank you for attending. At this juncture, can I ask Mr. John Mary Mugisha to come up and present the thematic areas of the principal concerns of the members of the bar. Mr. John Mary Mugisha made a presentation as well at the judicial conference, and I think a lot of these issues are cross-cutting. So if you can briefly just raise what those issues are, then we can open up the plenary for further questions and discussion. And we are looking for resolutions and recommendations. As the Honorable, the Principal Judge, the Chief Justice has said, what we want here is to find practical solutions to the issues that are facing us today. Thank you.
Thank you, MC Senior Counsel. My Lord the Chief Justice, my Lord the Deputy Chief Justice, my Lords, the Honorable the Attorney General, President Law Society, all protocol observed. As you may be aware, I had the rare privilege to represent the lawyers at the annual Judges Conference. I was asked to present the concerns of lawyers as far as preparing a people-centered justice system. This morning, I will simply give the highlights. I can assure you it was a very nice interaction, because I went directly, the gloves were off that day, and I hope I have immunity today. I will again present the concerns as communicated to me by the legal fraternity, but respectfully. There is a list that has been circulated. I will simply give the bullets in the interest of time. Our first area of concern is case backlog and delayed disposal of cases. Our main concern is that cases take long to the extent that we cannot advise our clients. The predictability. You cannot predict when a case will commence and when it will end. At the same time, you cannot predict when it has commenced, whether the trial will be consistent, and when to expect the judgment. We're also concerned with the summary disposal or dismissal of cases under the guise of weeding old cases. Some of these cases have been in the system for reasons not because of the litigants, but because of the situation that was obtaining in the judiciary then. As His Lordship was saying, cases, it's not statistics. You dismiss a case, reinstatement is not automatic. It has been in the system 10, 15 years. So you find the problem really once it is listed and dismissed for want of prosecution. So we are saying, much as there is that discretion, there should be a way of identifying the causes before they are summarily dismissed. Another area, of course, is judicial process inefficiencies. Here we have unnecessary adjournments, failure to allocate realistic timelines, overloading hearing dates, and lack of appropriate time slots. Here, of course, we, the legal fraternity, we are to blame for trying to abuse, much as the judiciary passed a very revolutionary law governing adjournments. There is a lot of abuse, especially on the side of the lawyers. And at the same time, there has to be a realistic balance. And this has actually contributed to the overloading of the system. Some judges list 10 cases on one day. All of you are expected to be in court at 9, and you do not know whether a case will proceed or not. Why do you have to load yourself with so many cases on that day? Why don't you give realistic time slots? You come at 10, come at 11, come at 4. Of course, some of the judicial officers do that. But by and large, that has been a big problem. The third area, judicial independence, impartiality and integrity. Of course, His Lordship has had the Chief Justice has spoken his mind, and the Land Attorney General. We have in mind the orthodox Bangalore principles of judicial independence. Much as judicial independence is not a myth, we should as much as possible respect the realistic, what they call compartmentalization of the arms of government is unpragmatic. But there should be, the way we are taught, those orthodox principles must be respected. There shouldn't be bad blood. It gives a very bad attitude to the citizenry. You try to keep it within the family, try to use other communications other than portraying a picture that the judicial independence is being eroded. So we as lawyers, it is also our honors to ensure that we protect that independence, and also let us stick to those principles which we were taught and are time-tested. Inconsistencies and quality and contradictory decisions. For goodness sake, why do the judicial officers do not respect the doctrine of stare decisis and precedents? We have time-tested decisions. Take time and distinguish if you would not want to follow. Do not make decisions per inquirium. Judgments are not only for the litigants and counsel. You are putting down judicial, the precedents. Therefore, generations, for posterity. We have decisions of the past judicial officers. We lawyers, whenever we get these decisions, we are looking for contemporary jurisprudence. We are looking for the law. So we get confused when we get judgments. I have listened to counsel. I have looked at the evidence. Honestly, I think we deserve more. Then, of course, contradictions. Judicial officers do not acknowledge other decisions. So we in the privates, we are confused, much as we were taught that judges can become wiser. For goodness sake, you acknowledge your brothers or sisters' decision and say you are not bound. Of course, that will be enriching your own decision and also ensuring that these decisions are tested by posterity. Another area is the area of infrastructure and technological challenges. We would like to commend the court for having introduced ECMIS. You know, some of us, the old generation, we still think that we can wait, and yet artificial intelligence, the chat what? Yeah, it's coming. But our problem is there has not been an organized way of migration to bring everybody on board in a uniform manner. The old cases especially, the cutoff point has been a problem. And some people, are not linked to the system. So we find a problem where one side is notified, another side is not notified. And the problem is exacerbated where you have self-represented litigants. Do you cater for them when it comes to ECMIS? We were told there were kiosks opened. Are the people aware those kiosks are present? Training. You have not deliberately brought a joint training where people are moving at par. Some of the lawyers, especially the young generation, they have caught up very fast. But some of us, we have to be appreciated. We cannot have the same way of handling matters. But we'd like to commend the judiciary. So far, so good. The same applies to rolling out the same system throughout the country. We should have uniform development. Let us have areas, the fat-rich areas like Kotido, Kisoro, and so on. They should also test the beauty of HMIS. Professional conduct and procedural issues. Disrespect of court orders. We, the lawyers, we are at a loss. Our orders which we get from court are subjected to a lot of reviews by, DISO, DPC, LC. Where are they provided for in the law? Their duty should be only to witness. So this is an area of concern which touches not only the legal practitioners, but also those who are supposed to witness, supervise. This business of clearing, of questioning, what role? Are you an appellate court? This actually creates a lot of distrust. The citizenry will no longer respect because the other arms of government are trying to do what they are not supposed to do. Of course, there are also delayed delivery and writing of judgments. Where did the 60 days rule go? Every judicial officer is expected to deliver his or her decision within 60 days. Some of the lawyers are saying they have waited for over 3 years. No judgment. Read it. Recently, there was a petition, a constitutional appeal. It took 5 years to determine that appeal. And do you know what the Court of Appeal held? It has gone into legal limbo of mootness. For them, they have a judgment there. What about the parties? Did you do justice? The term of parliament is over. People have been elected, but you have a hypothetical situation where you have jurisprudence saying the matter has gone into limbo of legal mootness. This is very disturbing. Why? Because of one reason or another, decisions were not handed on time, or the hearing was not handed on time. Then there is, of course, where lawyers do a lot of cyberbullying, trying to interpret to the public in a partisan way what courts have rendered down. Here I would like to appeal to my colleagues, please. You should not pretend, to tell what has gone on in court. That should be the duty of the PR of the court. Or if you opt, give an objective way. This is what has happened, and this is what is going to happen. Why are you disabusing the time-tested sub judice rule? You discuss as if nothing is happening in courts of law. This contributes to the people losing confidence. And at this juncture, I would like to appeal to the judiciary. You should have a vibrant PR. I remember when now Justice Karimani was manning that area. He would, all the time come out on time and say, this is what has happened, this is what is going to happen. Get a page today in court, on TV, what is happening. Try to go to all these social whatever and keep the public informed. You should have a budget for that so that you have impartial information which is not spewed or which is objective. There is another area of unprofessional exchanges between the bar and the bench. There used to be a lot of courtesy at the time we were joining the profession. There is a problem, especially the young lawyers. They think we, the senior ones, we have kept around for a long time. It's a high time that we are got rid of, or that we are dead wood. They don't know that the older, the wiser. The longer the wine takes, the sweeter. So please let us revive that mutual respect. And the bar, there is a lot of dressing down from judiciary. You undress us in front of our clients. We are unable to pay. So when it's, for goodness sake, let that courtesy be mutual. Or you say, can litigants step out? You guys, you are not properly dressed. What is the problem? Or, it seems you've not prepared. And actually that leads me also to preparation. We lawyers, we tend to take on so much. We do not look through the files. Our submissions are not addressing the current jurisprudence. We cite non-existent authorities. We even fail to distinguish. We do not volunteer to the other side, those authorities which are against us, as we were taught. What about you, the judicial officers? How many of you read through the files before you come over? For goodness sake, make a few notes. Put the relevant laws by your side, so that as you are moving, the trial is guided. There is another area now, adoption of, this should be the ethical conduct of legal practitioners. Of course, the exchanges. There was another area which was confusing the practitioners, the powers of the principal judge, the powers of the heads of divisions, where administrative powers start, where the administrative powers stop, and so on and so forth. We need to have that area clarified. Otherwise, you leave we, the lawyers, confused, the citizens confused, and there is a lot of, bad blood. Let's keep it within the family. Let us stay within the parameters. And if there is anything, let the court clarify those issues, interpret the law, and give us clear parameters. I'm almost concluding. Resource allocations and preparedness. Of course, we have to congratulate the judiciary. The numbers have now increased. I'm sure, but we need more. I've already addressed lack of preparation. Remuneration of lawyers on state briefs. There is lack of uniformity. At times you depend on the temperament of a given judicial officer, or magnanimity, or if someone is frugal, they will save in relevant areas. But there is a tendency of having an uniform payment, and that should be streamlined, because the presiding judicial officers are the ones who determine the type of remuneration. I think these are the main concerns. As you are aware, I presented a paper and I have circulated it. I can still circulate, I have it here. So some of the concerns which were raised by the legal fraternity are in that paper. And actually, I think I have tackled about 80 or 90% of them. Otherwise, my lords and honorable members of the profession, this is a very privilege which I even advocated for, because here we're able to face each other, we know our lanes, we should address the issues. Let us not kill the messenger. This is a legal profession. Let us try as much as possible, make it or keep it noble. We, the lawyers, should always defend the judiciary, and the judiciary should also respect the legal fraternity. My lords, I respect my presentation. I submit, and that's the end. I rest my submission. I'm obliged.
Thank you, our lecturer and mentor, Mr. John Mary Mugisha, for summarizing the concerns from the bar. Perhaps another round of applause for Mr. Mugisha's able representation of the bar's concerns. My Lord, the Chief Justice, and my Lord, the Deputy Chief Justice, before we turn to receive certain comments, reactions, and solutions from members present, I would also like to add two more concerns that I have seen online. From Mr. Collins Biamugisha, he's concerned about delays in signature of default judgments, and this is especially at the commercial court. He mentioned that that is a principal concern. We also have another concern addressed to the Honorable the Attorney General, and this is with respect to guidance on succession registrars and certificates of succession. I think this is a matter that you've ably opined on various forums, and perhaps you can summarize your position at the appropriate time. I would like to open up the discussion and contributions to the plenary present this morning. I recognize, yes, is that Mr. Barata? I recognize at the back. Yes, please stand up. If we could have the microphone brought to where our participant is. Please give us your name and succinctly state. I recognize Mr. Kanduo. I see you as well, Mr. I see you. Yeah, I see you. Yes.
Thank you very much. I'll start by clarifying I'm Mr. Tom Mbalinda, not Mr. Barata, private practitioner and also a lecturer at the Law Development Center. Thank you for this opportunity. I think we're here for solutions, and I just have a few suggestions. We agree that we have a challenge of very little time and too much to deal with by the courts. But it is very disappointing if you go to court and cases have been listed, blocking off a day, and not even a single lawyer proceeds. I think there's need to have an arrangement where lawyers who have been listed to proceed should be able to engage the judicial officer before the day of the hearing, so that if they will not be able to proceed, they are removed, and then those who are able to proceed are put on the cause list. Because it's such a waste of time. The court is full, and by 10 a.m., court is empty, nobody has proceeded. The other suggestion I have is clustering of cases, to have a time schedule, to know that within, say, 2 months or 1 month, these are the cases which have to be heard on the different dates, so that if a hearing collapses because of any reason which is not down due to the litigants or their lawyers, a short adjournment is given. Imagine a case doesn't proceed because of a conference or a meeting, and then it is adjourned to 7 months ahead. I don't think that's fair. There should be short adjournment, so that, within 2 months, these matters must be concluded. The third one is about the support staff. When judicial officers are not present, support staff are not there, and yet they are a very important cog in the judiciary, in the administration of justice. If there's a conference, all the clerks are not there, as if they're also attending the conference. These are people who are typing proceedings. These are people who are arranging files for hearings, and because of that, you take years to get a record of proceedings prepared. Can we have a clocking in system, an electronic system where everybody clocks in and there's a daily log of what you actually do as support staff? Because when they don't work, they affect our judicial officers. And then finally, stay of execution pending appeal. Me thinks that most of the appeals that we have in the appellate courts is because people want to avoid paying. I think until we streamline the principles upon which stay of execution pending appeal is granted, we are going to continue having as many appeals as litigants who are unable to pay. If it is a monetary award, if there's nothing going to be done that will obliterate or grossly affect the subject matter of the appeal, what are you staying?
Okay, thank you, Mr. Balinda.
Those are my proposals.
Noted. I'll ask Mr. Kanduho, please, to make your submissions, brief submissions. Thank you.
My Lord, the Honorable the Chief Justice, I thank you and their lordships for making time to come and be with us here. I thank the head of the bar for making time to come and make his presentation. Mr. Moderator, allow me legroom first to respond to the concern raised by my Lord the Honorable the Chief Justice with regard to the Bararo. My Lord, I own up. I am the one who wrote that missive. Not a single word was added, not a single word was subtracted. Quarreling in the courts of law, I used it in jest. Source of information as to where my Lord the Chief Justice premised his blame on the Bararo was the same source, my Lord, where you picked my missive. Secondly, my Lord, I had the honor of appearing before your Lordship in 2011. My Lord, you were presiding over Chisikirubyai versus Chinji. And you invited us in your chambers in Masaka. And we had a conversation in law management. After that conversation, my Lord, you delved into your experience of practice. And I recall my Lord telling us about two important things: real bias and perceived bias. It was my first time in my practice to get an able and succinct distinction between real bias and perceived bias. And you gave us a case study where you were representing Professor Isaac Newton Ojok as an accused person by the government of Uganda, before my Lord now departed Catherine Byamujisha. And you raised the point of recusal to the effect that, to the extent that my Lord was married to Dr. Joseph Byamujisha, now departed. And he was a sister to Right Honorable Elia Kategaya, who was a senior government official and the first deputy prime minister in Yoweri Museveni's government, who was responsible for the arrest of Professor Isaac Newton Ojok. You thought at the time of your practice that that was bias. In the same shoes, my Lord, we tend to think that there should be a moment in time when the Chief Justice retreats for fear of being perceived to carry perceived bias. When a Chief Justice, my Lord, is so passionate about a subject, and I know you are so passionate about so many things, but to the extent that you are a Chief Justice, my Lord, time comes and you must retreat, because the cross you carry is such that you, your Lordship, must at some point retreat. When you're so passionate about an ethnic group,
Mr. Kanduho, let's be a little guarded with
yes,
our
my Lord.
comments.
And my Lord raised it. The Bararo issue is an ethnic matter, my Lord.
My Lord, the Chief Justice didn't say that. He said it was a national issue, which was right to the.
All right, I think the point has sunk.
Let's measure our.
Secondly, I have three other concerns. One on the developing nomenclature at the bench. Sensitive cases. When did this term come into our jurisprudence? What amounts to a sensitive case? Two, urgent matter. Who defines that matter A is urgent, matter B is not urgent? Who defines that? Three, as a litigant or counsel for a litigant, at what point do I become aware that my fixture before court A will be handled in a week, as opposed to my neighbor who has his fixture handled in a day? I have had matters, my Lord Chief Justice, where somebody files a matter on Monday, they have it fixed on Tuesday, it is heard on Wednesday. I have had an experience where I file a matter in year A, it takes 8 years, no fixture, notwithstanding that I am on the road on a daily basis, ensuring that the matter is fixed. My other point, my Lord, I am happy my Lord Justice Kavito is here and some members of the commission. We talk in the corridors as lawyers. And I am sure everybody here who has been a lawyer has had opportunity to have a conversation in the corridors with colleague lawyers. At what point did we begin to get judges who cannot differentiate between a ruling and extract an order that is consistent with the ruling? At what point did we begin to sieve and usher out judges who cannot even take a record? At what point in our history did we begin to get judges whose judgments are written by their research assistants? Because we talk in the corridors.
Mr. Kanduho,
These are living things.
Mr. Kanduho, I think the Attorney General said if we have particular instances
Yes.
where there's an issue, we must state the date and the time. We must particularize.
I will give
we
them.
are advocates.
Yes,
so
I will
we
give
must
them.
have our evidence and particularize.
I will give them in confidence because I can't address
But I
a
think,
judge.
I think
in
Mr.
the hearing
Kanduho,
granted
the
for
general
others.
issue you're raising is about the inspectorate. How effective is the inspectorate
No,
of courts
not that.
to monitor how the judges and judicial
I am not
officers
talking. I am
are
talking
working?
about the point of ushering in Kanduho as a judge, Adrico as a judge. At what point did that begin?
Okay, I think we will ask. We will
Yes.
give, we will
My-
give the opportunity.
my
to the
other
Judicial
point of
Service
concern, my Lord
Commission to
CJ,
respond.
is with regard to bail. When I had just started my practice in 2005, the first experience with bail where somebody is required to deposit a land title was in the case of Dennis Obua. Does it shock you, members of the bench and the bar, that the bulk of Ugandans don't have land titles? This requirement of deposit the land title, deposit the land title, deposit the land title for every bail application, who is the mother of this requirement? Is it our legal jurisprudence? Is it our statute books? When did it come? When did it become part of our practice? Do you ever think about people who are landless and they require bail? Do you think about people who hold land on customary basis and they require bail? Finally, insurmountable amounts of cash bail. I have had an experience, my Lord Chief Justice, where I read in the newspaper that somebody was arrested on Kampala Road. He was brought before a magistrate's court at Uganda Road. And he was required to deposit 30 million Uganda shillings cash. What was the offense? Loitering on the street. What was the name of the suspect? Chiza Besigye. I can be a Chiza Besigye anytime. Anybody here can be a Chiza Besigye. Let's create a fair ground for access to bail. I thank you very much.
Thank
And
you,
good
Mr.
afternoon.
Kanduho. Thank you for your submissions. Mr. Max Mutabingwa.
Thank you very much, Mr. Drico. The Honorable the Chief Justice, I can note that this bar bench of today is different from others we have heard before, because I can see today there are many judges of the Court of Appeal. Even we have the Chief Justice and many judges of the Court of Appeal. It has never happened before, and I thank you all for coming. My first concern is that every year we have been having a bar bench, and I have always attended. I never miss this one because it is very important. But what disturbs me, whatever resolutions we make, they are not implemented. So I suggest that we should have like somebody who is writing all these suggestions so that after here we can put them into practice. Because whenever we come here every year, we speak very good English, very good. But when it comes to the implementation, there is nothing which is implemented. And then next year, we come back. We talk the same English, even better. So let us record our resolutions so that they are implemented and our meetings are not in vain. My first concern, I have had the Honorable the Chief Justice saying now we have many judges, they have improved the courts, even there are some courts in the villages. That is very good, and that is commendable. But there is a problem which you are not seeing. Maybe my fellow advocates have seen it. It is not the quantity of the judicial officers which matters. The quantity is very important, but the quality as well. What quality of judicial officers are we putting into the system?
Mr. Mutabingwa, I think that point was raised by Mr. Kanduho.
Yes.
And we shall get a response from the chairperson of the Judicial Service Commission who is present.
So I'm
You can
stressing
move
that
on. Yes, you can
the
move on.
Judicial Service Commission has done a very commendable job, and they have appointed very wonderful judges, very good. But some judges don't measure up.
Well,
You go to court, you appear before a judge, and then in your head you start thinking, is this a judge? Did he go to LDC? Does he have a degree in law? And then you start quarreling. The fighting starts. You see, that's how the fighting starts, I'm telling you. So there, by appointing many judges, you are treating a symptom, but not a disease. So we have to go back to our system where the good judges were being appointed. And we had a very good time. I started my practice in 1998. We had a very good time. But things have changed, my road. Things have changed. Sometimes we don't want to go to court. Sometimes if I know that I'm going to appear before a certain judge, I give the file to my colleague. I cannot appear before him because I am not going to get anything from him. Judges, we are supposed to learn from you. Actually, a judge, I have always insisted, a judge should be above counsel so that counsel can learn from the judge.
they are above council.
Yes, but
They render decisions.
you should measure up. When I go and appear before you, I should learn something from you, not you to wait to learn from me.
Okay. Can do. Perhaps you can move to the next point.
It is
Conscious
not
of
good.
time. Let's be conscious of time.
You see, a judge is like God.
Yes. Let's move on. The next point.
Then, in addition to that, judges don't prepare. You see, you have listed 10 cases on a day. How will you read all those 10
I
cases?
think Mr. John Mary Mugisha touched
Yes.
on that.
Then there is a very big problem now. We have always talked about it every year. Every year we come here and talk about this problem. We had agreed that, especially up-country courts, that when counsel are going there, and the judge is not there, if the judge is not going to be present, they should inform counsel in advance. Last month I traveled to Mbarara. I drove from here to Mbarara. Reaching there, I was told, you see, now the judge is on a session in Mukono. Why wasn't I told? I have burnt my fuel at the expense of my client. So, and we have always talked about that thing every year, but it has never been implemented.
Point, Mr. Kanduho. Yes, it has.
The other
been
time
raised.
I drove from here to Soroti. The same thing. So that thing should be tackled effectively.
Communication.
Yes, communication. They should tell us. If the judge is not going to be there, they should tell us. Then, the Attorney General now, I think this is like an injunction which has been slapped against the URS, has said that if you want to talk about corruption, that you give evidence. But I have always insisted that the evidence of corruption is like evidence of adultery. It is circumstantial. Sometimes it is not direct, but it is there. You see, adultery, you not find somebody on top of another. No, it is very hard, but it happens and people know. So that is how corruption is. And I have always insisted, if you want to see how corrupt a judicial officer is, go to his or her rulings and judgments. Some judgments are riddled with corruption from the beginning up to the end, and incompetence. So, Attorney General, sir, I would suggest that the Judicial Service Commission should appoint like a committee to continually assess the judges. Some judges don't measure up. Put their committee, look at their rulings, look at their judgments. Do they measure up? Maybe after a year, you can see that this judge is very dangerous to the public. And it is.
Mr. Kanduho, perhaps we will allow the other participants to also. Mr. Mtabingwa, I beg your pardon.
Now I have two comments.
Yes.
I have two comments. Two other comments. One, we have our Court of Appeal, which is very efficient. We have very wonderful judges there. But in my opinion, the judges are very few. And you see the appeals which come from the high courts, they overwhelm them. And getting a date for the Court of Appeal is very hard. And you see, like now, Iran matter. You win Iran matter, then somebody applies for stay. Stay is slapped. 10 years, an appeal is not hard. So, what kind of justice is that one? That one also should be looked into. But I'm not saying that the judges of the Court of Appeal are bad. No, they are very wonderful judges, but they are very few.
Okay, Mr. Mutabingwa,
As well as This is my final point.
Yes.
As well as the industrial court. You should also look at the industrial court. Industrial court has only 2 judges, and it serves the whole country. All cases which have come from the whole country, they are applied at the industrial court. So how can two judges handle all the matters of the industrial court? And sometimes they rotate. They go to Mbarara, but leave the cases of Kampala. Then they go to Jinja and leave the cases of Mbarara. So I don't think they are treating any disease there. So they should be helped also to add more judges.
We shall ask Justice Mugisha to make a comment.
Thank you very much for giving me an opportunity to speak. Thank you very much.
You'll be happy to note that a lot of your comments have been re-echoed online. A lot of your comments have been re-echoed and you've been uploaded. Perhaps I'll also just read what Senior Counsel Lydia Ocheng Obo has to say. She's concerned about, she's online, she's concerned about dates, revision of consent dates. When council agree by consent to particular dates, these dates are revised without participation of council. And she thinks that the court can be more proactive in engaging council before those dates are revised. I will now go to my sister.
Thank you so much. All protocols observed. My name is Anne Karunji. Mine is a point of correction to our learned Attorney General, who mentioned in his speech that the judiciary is a client of the Office of the Attorney General. The judiciary is a well-known, well-respected, independent arm of government, and as a legal advisor of government, we are cognizant of the fact that you work hand in hand with that well-respected old institution. So to say that they are your clients is to, with all due respect, put it incorrectly, and mine was a point of correction. Then secondly, also to our learned Attorney General, is I need to understand why is it that there is always a combative approach between the Office of the Attorney General and the over 50-year institution of the Uganda Law Society. It has reached an extent where the country is worried. Our people are worried. They are like, why are you at loggerheads with the Office of the Attorney General? I think we need to sit together, because you find that even the points, how it's blown up in the media, is not what is on the ground. We need to change the record in the media and to the country, because you are the head of the bar and well respected. We respect the Office of the Attorney General. So we need to address that matter so that it doesn't affect our joint dealings and also our people, you know, the justice users. I thank you.
Thank you, Mrs. Karunji, for your intervention. I'll take 2 more here and 2 more online, and then we shall ask for a response from the honorable judges and judicial officers present.
For purposes of seniority. Thank you. Thank you, my Lord, the Chief Justice, and the President, Uganda Law Society, as the heads.
Mr. Opio, yes. Yes. Milton Ochen.
My name is Milton Ochen.
Yes.
I thank the heads of both the judiciary and the Uganda Law Society for this very noble dialogue. Allow me just draw back a little bit and state our relevance. We all do know. I come from a commercial arbitration practice area. And these days when I go online and look at what is going on within the judiciary, and I'm glad we have this forum, the battling between the bar members, the bench, it's not healthy for our country. That is where I come from. And when we travel, anywhere you go, especially for professional engagements, you introduce yourself as a lawyer, the respect you're given is very high. Why am I bringing this? To allow us reflect internally. and see how best we can forge a way forward. There's a direct correlation between the image of the judiciary, or the legal system for that matter, and Uganda as an investment destination, Uganda as a country. It also applies to the human rights practitioners. For example, these things in the social media. Yesterday I was being given some wisdom by Justice K. I was consulting him on a presentation I'm making tomorrow. And with these online search engines, when you put in certain things, you see the results that pop up. We need to be aware of this. It looks very simple and minor. But at the end of the day, if both as members of the bar and the judiciary, we do not uphold this noble profession that we are called to, it will cost all of us in so many ways. What am I saying? One, we have a collective responsibility to restore the public confidence in the judiciary and the legal system as a whole. We need to perceive the role of the bar. Of course, my Lord the Chief Justice will have another engagement, and I request through the President, Uganda Law Society, we meet as the bar alone, because I wouldn't want to start undressing ourselves in front of the other dialogue members of the judiciary. We also have in-house issues to deal with as lawyers. This is a noble profession. We need to hold ourselves accountable. Running social media all the time is not the solution to some of these things. Because at the end of the day, if I'm portraying the judiciary as rotten or corrupt or dirty and what and so on, I am not benefiting anything as a lawyer. That reputation goes with me wherever I go in the world. And that affects us as members. So because in the commercial space, we are competing with lawyers all over the world. Sometimes we're asking ourselves, why can't I raise a fee note of $1 million? While somebody across in Kenya, Nairobi, is raising that fee note. Some of these little things contribute at the end of the day. I'll make a few suggestions, my Lord. I know it's a high dialogue.
Yes, Mr.
One,
Milton, perhaps you can summarize.
Yes, my Lord.
I'm very conscious of time.
Yes, my Lord, through you, the moderator, I will. One, we need to create an independent guardian for the legal system. I am borrowing this from the UK, where government should consider setting up an independent guardian for the legal system.
Can you say that again, please?
Government needs to consider, we need to consider setting up an independent guardian for the legal system. What I mean by this is that Guardian. Yes, like a guardian.
Okay.
The UK has done it. India has also done it. So we could create a center for this legal center. And what does it do? It does many things. It could act as a single forum for better and transparent dialogues between the bar and the bench. The Chief Justice did say how he wishes this could be continuous. But once we can have an institution, and I do know also we have a Judicial Affairs Committee of the ULS, they need to step up their mandate to ensure that we make the best use. Some of these...
Okay, so you want to institutionalize the bar bench engagement?
Yes.
And Mr. Mutabingwa said that we should not just have resolutions, we
Yes.
should ensure there's follow-up. And indeed, I think this is a sentiment that the President has as well, and perhaps will address when he's summarizing his remarks. Perhaps we can move on?
Yes, so this, just to summarize that, so this becomes a grievance resolution mechanism that resolutions are taken up and implemented. We need to constructively engage the bar as an administrator in the legal system. We have a role to play. If we go to sections 3 of the Uganda Law Society Act, there's quite a bit there. And both the judiciary and the bar, we need to recognize this and see how we can work together too. As a bar, my other suggestion is that we need to rebrand our image. We need to build a citizen lawyers initiative, which is very, very important, and know where to, because if we know that if you are attacking the other, you are attacking yourself, so that we can also regulate within ourselves. We do not wait for law counsel to rein in on the membership. We can do much better as a bar to streamline our behaviors and conduct. We can sit, we quarrel, we say, you know what, here, this was wrong, this was bad, we need to do better. So that we can then have the moral authority as well, and not just the legal.
Mr. Ochen, I'm going to ask you to...
I'm just going to add one.
Yes, perhaps.
Which is more at a policy level, engaging and encouraging a vibrant democracy within the legal system. I'll stop there, but I'll be available to elaborate more. Thank you.
Thank you. I'll take one intervention here and the last two interventions from Senior Counsel Ruhindi and Senior Counsel Lule.
Thank you very much. My name is Philip Munabi. I think much of the reason we are here is the moral degeneration as a law society. We are losing the fiber of morals. Let me start with the solution. We have senior counsel here by rank and repute. I think we are not taking use of them. We should resolve here that the senior counsel by rank and repute be tasked to act as I think what my brother calls the guardian, to act as a bridge between the bar and the judiciary or the bench. Unfortunately, because of moral degeneration, we are looking at age as an item. I've recently had this use of social media. I had a quarrel with a doctor, full doctor, I won't fear to mention his name, Daniel Waliemeda, one of the petitioners, saying that the Attorney General is saying nonsense. I read the post and say this man has a problem. So we need to have checks. This is a lecturer at one of the institutes. He's lecturing to students who are going to be lawyers tomorrow and come into the profession and start attacking judges and senior lawyers. So I think we need to resolve that we take use of the senior counsel and task them to check on certain issues that make us reach this bitter. From the universities, this senior counsel committee or forum should be checking out who is lecturing these students, who is engaging with them before they come to the bar. Because when they come here, when we join the profession, we get this feeling that we are equal. We are equal. I cannot be equal with so many of you here. I cannot. I just joined the profession a few years ago. I cannot start equating myself to senior people. When we were at law school, Makerere, one of the most awaited lectures or items was Senior Counsel Ruth Sebatindira is coming. Senior Counsel Professor Sempewa is coming for a lecture. That is what we wanted. That is what we wished for. We don't see it anymore. All we see is populists flying all over social media. There's a team, I won't even fear to mention also, there's a team of people calling themselves rule of law, the rule of law movement, human rights activists. They're abusing everyone. Let's constitute a senior counsel forum to check these people.
You've made your point.
Thank you.
Counsel, the senior counsel forum. I will now ask former Attorney General Ruhindi to intervene. Senior counsel.
My Lord the Chief Justice, and I will stand on the protocol already articulated. Mine is a comment principally in some few areas. One, on this matter of independence, separation of powers. Separation of powers, as we all know, or as we may know, is an expression which came in vogue during the olden days, particularly the 18th century, around a revolutionary term, separation of powers. It served its purpose, and it is still serving its purpose. But I think in modern times, we may be inclined speaking more in terms of complementary powers than separation of powers. Why? Because really, where we have reached, and we have actually built this in our constitution, we talk about the common good. We talk about national interest. When you look at Article 126 of our constitution, we talk about without undue influence, but it's not a shield against accountability. There is no way, for instance, if Parliament appropriates your resources, they call you in Parliament to account for those resources, and you say you are independent. You must go and account. Yes. So, to me, in short, on this particular matter, let me end it on this note. There are certain matters, my Lord, the Chief Justice, where communication is good. It's okay to put something on record. But there are certain, for instance, when you take the judiciary and you take the executive, I'm afraid the moment you allow this exchange of letters, it can create a problem. Today it may be you, the Chief Justice, we know, Justice Onyindoro. Tomorrow it may be another. The head of state will communicate in writing, and the Chief Justice will also communicate in writing. The President will communicate in writing. So now what happens at the end of the day? My view is that there can be interaction. Give yourselves schedules when the executive and the judiciary can sit together. I remember during our days, even I remember at the time of the Black Mamba, we had to sit with the president and explain. And at that time, there was an impending demonstration by the lawyers. And we sat together and we agreed on the way forward, and the things calmed down. So my advice is that let there be these regular and timely interactions, because they put a brick in the building process of Uganda. Lastly, there was something about contradictory judgments, but I think this does not address that issue as such. But I think lack of uniformity, lack of consistency on certain precedents. And I think the Attorney General, you will agree with me, that for instance, in the award of damages, the award interest, in the award, there is no consistency. And this can be a drain on the exchequer. I had advised when I was in that good officer that like the judiciary developed guidelines on sentencing, we could have some guidelines also developed in the award of these damages, interest, and so on and so forth. Thank you so much. I rest my case.
Thank you very much, Honorable Fred Ruhindi, Senior Counsel, for your intervention and proposals. The last word will be by Senior Counsel, also a former Attorney General Lule. I believe he had his hand up. I see it is down. Perhaps he's changed his mind. Oh, okay.
Thank you very much. One of the last speakers said, today, lawyers speak good English and very good English. I apologize if I cannot be heard to speak that good English. Because at my age, 92 years now, I may not be able to do it. I have been at the bar for 63 years. Before independence, I was in the Department of Public Prosecutions as a prosecutor. And later on, I went my ways. I have heard what has been said here, and I would like just to emphasize what my last speaker, Senior Counsel Ruhindi, has said. And that is, what we do should be gauged by and guided by national interest. That national interest encompasses all persons in our country. And therefore, everybody, whether lawyers or not, have that interest. And we should care and cater for that national interest. So I suggest that someone has hinted on it, that we set up a kind of mechanism where we can have regular interactions on many matters, so that we make, as lawyers, our contributions. Lawyers are not so different from judges. One is mother of the other. And mother and child must always have that connection, which cannot be broken or set aside. And therefore, if a child is hurt, the mother feels the pain as well. So we should not act as strangers, but as complementaries to each other. With that, I suggest that we find a way of setting up a kind of a mechanism, a committee, or whatever you may call it, whereby we can sit regularly at given intervals, not just waiting when something happens, but have regular meetings as you may decide, to look at things and how they are going, to grow our profession, to clean it, and not wait until we have got guests and clean the house. This is my contribution, and I thank you very much for this meeting, which I have enjoyed quite well. Thank you.
Thank you very much, the last two speakers, for your words of wisdom. And thank you for attending Senior Counsel Lule. We shall certainly on board your suggestions. We are indeed mother and child, or indeed sister and brother. We are co-members of our profession. Thank you. At this stage, I'm going to ask His Worship James Mwanda to come up and take us through the next session, where we are going to ask our judicial officers to intervene as and when necessary. The Chief Justice will determine how that intervention will take place. Thank you.
Let us give him an applause for steering us through up to this moment. And let us also thank ourselves for giving us this kind of good feedback. It has been very good from the bar. And my Lord, Honorable Chief Justice, amidst us we have the justices and the judges of the courts present. And we believe that some of these comments which were raised by the bar, the concerns, some of these could be matters that could probably we can have responses from the judges and the judicial officers present. That we also need to have some comments, if any, from the judges before we shall request that the panelists come in to make their responses. Judicial officers present, I can see Honorable Justice Madrama, I heard even the Chairperson Judicial Service Commission. Can we have the mics so that we can have these responses. We could start with Justice Madrama.
Thank you, my Lord, the Chief Justice, Honorable Attorney General, all protocol observed. This is a very exciting time when we can interact. I wish particularly to talk about case backlog and delay of cases and the aspect of the number of judicial officers which has been increased. Historically, the High Court had very few judges, possibly a handful. Now we have about 78, 82. Now, I have for some time been looking at the structure of this. As the economy has been growing, more and more cases are pushed to the High Court. The Land Act, the tribunals have their cases not heard by anybody, so most probably all these cases will end up in the High Court. So you expect that the High Court will never be able to cope, even if you appoint 140 High Court judges. One of the ways is, to deal with the low esteem accorded to the lower bench. If, for instance, a chief magistrate can only handle 50 million, I know there are proposals to increase the pecuniary jurisdiction of chief magistrates and magistrate grade 1, but there is a tendency of people to push things to the High Court. Now, the law itself has not helped. With the growth of the economy, how can you have a chief magistrate comparable to other jurisdictions have a jurisdiction of 50 million? I think their jurisdiction should be over 500 million, and they should also have jurisdiction in land matters, because the country is growing, developments are coming up, transactions are taking place, the economy is bigger than it was 20 years ago. So as more development continues, you'll see that the pressure on the High Court will be increasing. So whether we like it or not, we have to pass this power to the lower bench, increasingly, so that they can spread all over the country and be able to handle the vast majority of cases. Now, the reason this is that if you appoint 82 judges in the High Court, it means that the number of appeals to the Court of Appeal will increase. And these 25 people is just a drop in the ocean. They are not going to handle these appeals because there are too many appeals for the Court of Appeal. So, in other words, structurally, we are drowning ourselves without addressing the underlying causes. I mean, why should cases be pushed there? This matter belongs to the High Court. It's going to affect the number of cases in the Court of Appeal. It's going to go up as second appeals to the Supreme Court, when you could have controlled it, start from the lower court, have appeals to the High Court, second appeals to Court of Appeal on the points of law. Rarely, High Court hearing cases with higher pecuniary jurisdiction. Then you'll see that this backlog and clogging of the system and quality of judgments will improve. There will be better administration of justice. But what I wanted to ask the members of the bar is, why is there so little respect for the lower bench? Why are their powers being taken away? And are they not from the bar? What is the problem with having power at the lower level? Thank you.
Thank you very much, my Lord. Let us have responses from the Chairperson, Judicial Service Commission.
Thank you, Lord Chief Justice. All protocol observed. I think the underlying issue is, as a society, our morals have degenerated. As a society, we must be frank. Ethics, integrity, our ethical foundation, our ethical fiber has been eroded. And this has now come to the legal profession, and it's from the legal profession that we get judicial officers. So this is we need to deal with it. There is a feeling that we have too many lawyers. We have 2,000 lawyers in the Law Development Center, and only about maybe 300 can be absorbed in government. And we are aware that law firms are downsizing. Where are these other lawyers going? They are going onto the streets and they are being recruited by other actors, mindful that they have judicial knowledge and other knowledge, and they are creating havoc. We need to have a conversation on how many lawyers should be trained through our system. In Ghana, for instance, they limit the diploma course to about less than 100 annually, among the best. We need to have a realistic conversation about that. The other is the management structures in the judiciary, where you have the Chief Justice delegating functions to the Deputy Chief Justice for the Court of Appeal, Principal Judge for the High Court. That was for us a small judiciary, as my brother Justice Mandrama has just remarked. That was a small judiciary. You need to review the whole legal regime of the judiciary to provide for quality assurance. I'll give you an example. Justice Wambuzi, and I'm here, I'm being very respectful to you, Chief Justice, but Justice Wambuzi, because of the small numbers, used to have a tea meeting with all the judges on a Friday after requiring that they submit their judgments to him. And during that tea, if you talk to Justice Monda and Justice Mahangusia, you'll say he pulled out the judgments and all of them had marks in red. He had read them and there was a point he was going to raise with all the judges at a sitting. So there was common learning, common direction, common comments made among peers. This the Chief Justice cannot do because the numbers of judges are 82. The principal judge cannot do it because you're now having 82 and maybe soon 150. So we need to have structures within the judiciary of quality assurance, and it means auditing of judgment. And since we are supposed to make suggestions, I would support a team comprising quality assurance officers from the judiciary at all levels of the court, the Law Society, and the Judicial Service Commission to audit judgments at peer level and guide the judicial officers on mistakes and errors that are coming through. Contradiction. All this is because we don't have the supervision. There's a supervision gap, and it's not anybody's fault. The management has not caught up with the numbers. The numbers are many. We need to go back to the review. The issue of quality judgments, I've touched upon it on the review, but the principle of the Judicial Code of Conduct, number 6, is on competence and diligence. A judicial officer must be competent. And I remember the Tribunal of Inquiry on Justice Oteng. It was based on incompetence. And the threshold for misbehavior and misconduct was very low. and really we are surprised we have not got complaints about competence of judges. When you talk to some legal practitioners, they say, no, we are reluctant about coming to make a complaint because we have to appear before these judicial officers. You're not helping the situation. You need to be bold, come and make complaints, even among judges, so that we can take it up. On all these grounds, issues of research officers writing judgments. We've had cases where lawyers have been called by research assistants that I'm going to write the judgment, but no one is coming forth. We need to have evidence-based complaints in order to really deal with this issue. On recruitment, we are recruiting from society, and already I have explained the issues. However, you need to have the Judicial Service Commission go beyond a mere part-time with part-time membership. We need to strengthen the Judicial Service Commission if it is going to do its oversight role of the judiciary. Increasingly, with the numbers of the judicial officers going up, the commission is increasingly dysfunctional. It's not capable to deal with an enlarged judiciary. This, as at 1985, the Constitution, 95, what was envisaged was the High Court was number 32. 32 judges, Court of Appeal was about 11. But now the numbers are gone up, and your Judicial Service Commission is largely with part-time members. We are not even able to hold 2 meetings in a month. And we don't even have the capacity to do background checks and also intensive vetting. We don't have that capacity. So we need to look at these institutions and reform them and strengthen them as part of the overall reform of the judiciary. I think those are the remarks I had to say for now. Thank you.
Thank you very much, Chair. If we have any other comments, yes, we have Justice Chirawire from the Court of Appeal. Please. Point is, we are recruiting from the community of advocates. So we need to up our game, the community. My Lord.
Thank you very much for this opportunity to interact. My Lord, the Honorable, the Chief Justice, allow me to rest on the protocol that has already been outlined earlier. I'd like to also add my voice that indeed this has been a very good approach to have a bar bench so that we can have an opportunity to hear from both sides and look for solutions. I am really looking forward to a way when we can have action points which are directed at solutions, having identified the problems. And I want to go into some of these. The first one which I'd like to highlight is we also have a spin-off of Bar Bench, and that is the Court Users Committee. And I think we need to really add weight to these Court Users Committees. In the Court of Appeal, we have instituted a Court Users Committee. And I think it is in its early days. I think we have had 2 or 3 meetings, but would like to see greater participation at the Court Users Committee, so that even as we move between the formal bar bench, these Court Users Committees are very active. I recall during the time I was at the Commercial Court as head of the Commercial Court, we had a very, very vibrant Court Users Committee, and it had a very important effect on the efficiency of that court. And I believe at the time that court was performing quite well. And one of the reasons was that the Court Users Committee was very active. And so I'd like to see court users committees across the divisions, across the circuits, even at the chief magistrates levels. I'd like to see these being very active, and I'd like to implore the bar to be active in these court users committees and raise these issues before it becomes a problem. Actually, we are adopting even interesting practices. We are pushing the boundaries of how interactions between the bar and the bench take place. Just to give you an example, as part of our court users committee in the Court of Appeal, we have now created a WhatsApp group, and we have rules, and we get information on real time as to what is happening between the bar and the Court of Appeal. Those of you who are on it, you know how it is working, and it is helping us to do what is possible in the Court of Appeal. Perhaps that's why Council Marx did not put venom on the Court of Appeal because we have a good working relationship with the bar at that point. Now, the other area I'd like to talk about as chair of ICT in the Uganda judiciary is this onboarding of ICMIS. One of the things that is for certain is that it is not going away. It is the future now taking place currently. Yes, it is not countrywide, but I'd like to confirm that we have a rollout program to go around the country. It is not a system which we are going to drop around the country immediately. There are other issues which we need to take care of, things like we're using the NITA fiber optic cable. There are some areas up country which do not have access to that cable, so we cannot deliver it there. There's the issue of consistent power supply in some areas. We need to deal with those issues. There are issues also of good internet because you cannot use it if you don't have these elements. So we are going to spread. Now on training, we have done a lot of training for the bar. We have done a lot of training. If you have missed, let us know so that we can get to you, so that we can help you to get on board the use of ICMIS. We have a change management policy. We have trainers, and we have trainers of trainers. And if you're even willing to come to us and say, look, can you do it at a chamber level? We have actually sent our team to chambers and trained them. So that should not be a problem. We are alive to absorption of ICMIS, but we need to work together to make this happen. Now, there are other issues that training has not achieved. One, we tell you how to use ICMIS, but there is still a problem, one, of trying to deal with the standards. We have told you what sort of equipment to use. We still have people scanning documents using mobile phones, and the document is queued. Uploading it becomes a what? A problem. We believe that this is, like the Honorable the Chief Justice has said, this is the fourth industrial revolution. We imagine that you have proper scanners in your what? In your chambers, 2024, you know? Yes, because this is your document. This is the document that you're going to plead with. Give us the best quality. Give us the best quality. Sometimes we have to reverse those entries. And that creates further delays. And remember our system, when you come in, we start giving you numbers. We have a footprint of when you come in and when you go out. That confuses our system. So please try to also as the judiciary improves its infrastructure for IT, let the law firms also improve their own infrastructure for IT. I want to talk about delays in judgments. And even though there has been good feedback that for example, speaking for the Court of Appeal, that you're getting your judgments and rulings, you now see them coming out. I'd like to point out that we are writing more rulings than we're writing judgments. Why? Because for some reason, every appeal comes with a minimum of 2 applications, sometimes 3. And I can assure you as court administrator, there is greater pressure on me for applications than for judgments. And the basic applications are stay. We're the Court of Appeal, but sometimes we are starting to become the Court of Stays, you know? And this is affecting the quality of service delivery, because if we have less applications, it means there's more visibility for us to deal with the main appeals and resolve the issues once and for all. As we speak now, the Court of Appeal has crossed the 10,000 matters level. So in terms of matters in the Court of Appeal, we have crossed 10,000. It has never happened before. 50% of these applications. The subject matter which will make a difference for your parties, just about 50% of that workload. Why can't we work together? Remove these other things and give you judgments. Because if the number of rulings we wrote were actually judgments, I think there would be no complaint around the Court of Appeal. The other thing I'd like to talk about is efficiency. A lot of people have raised the issue of efficiency within the court system. Now, I'd like to say that we have preparation, we have scheduling, and we give timelines. And again, I speak for the Court of Appeal. It may not be necessarily the same for the other courts. And with this kind of backlog, we expect that people are very anxious to follow these timelines. But actually, the truth is, quite a number do not. So when the cases are fixed, you actually do not have people who have prepared for them. For example, filing of submissions. And now they have many applications. My Lord, let us proceed in spite of the other party not having filed submissions. And it makes, this dialogue is not really efficient, it is not professional. If we actually have where both have not filed submissions, and that is on the next, that is, for example, in a civil session, that is a case that is going to be on the next civil session. There are no submissions on file. There are no authorities on file. The parties did show up for scheduling. Have they lost interest? Should we reschedule it? Or should we hear it as it is? And that's the policy that we're taking now. If you have scheduled, we have given you a timeline, and you come on session, we will hear the case as it is. And then we'll see how to progress. Finally, I'd like to, I cannot leave such an audience without talking about the use of alternative dispute resolution. It is amazing how many cases, I remember as a high court judge, you start a case, the case settles. You start a case, the case settles. So is it because it is before the judge, now the parties are willing to consider settlement? The idea I want to put forward is, can we start adopting the use of alternative dispute resolution even before the case is fixed? Right now, we are pushing for appellate mediation. There was a thinking that it was impossible to mediate a case where there is an existing judgment. I think we have debunked that. And now we are running at a level where we have appellate mediations that are equal to court sessions. And people are getting out of the system quickly. Can we find a way where we can improve on the use of negotiations before you go to court, so that truly what comes before the judicial officers is what you do not agree on? But we even like on the Court of Appeal, you come with 20 grounds of appeal. Yes. And the first thing that happens is, Your Honors, we want to abandon ground 1, 2, 3, 4, 5, 6. And preparation has gone in that case for 20. Then it comes to 1. I don't know where this came from, but it is becoming a problem. Is it possible that if the truth is you only have 1 ground of appeal, give it to us? It may help us to schedule the case faster, which may even allow us to put it to mediation track, so that really we ensure that, my Lord, the Honorable the Chief Justice, we want to move from the era of litigation to the era of dispute resolution. If we can have that agreement between the bar and the bench, that our system is designed to resolve disputes and not litigate. Litigation is part of that process, but that is the general direction. I think we'll have a better outcome. I thank you.
Thank you very much for those contributions. My lords, I know that the time is not on our side, and I can see there is one burning issue from the land division. My lord, with your permission, let me take that from the land division and the industrial court, and we should be good to go.
Thank you very much, Worship. My Lord, the Honorable the Chief Justice. Regrets from the head of the division. I'm not the head of the division. The head is well known. She's unable, she's indisposed for known reasons. But land division happens to be a division with the greatest pressure for determination of issues. And so, one of the biggest challenge the division faces is about hearing deaths. The head of that division spends almost half of her time dealing with complaints of failure to give a hearing date. In fact, I feel sorry for her. When she delegates to me for a week, I almost run mad. Every advocate who has a case in the land division wants their case heard the following day, which is not possible, because the workload per judge now, my Lord CJ and honorable members of the bar, the average case per judge is in the region now. By the time I joined, it was 1,000 plus. Speaking for my docket now, 800. Now multiply that by the number of judges in the division who are around 10. So you can see the workload. Now, the challenge we get, it's good the bar has pointed it out, that judges have a temptation of attempting to deal with the entire caseload, which is not possible. And so, because of the pressures from the bar, judges who are very, I call them diplomatic, very nice, they spread their dates. This lawyer comes, your case is May, your case is August, your case is December. And so, output becomes a problem. Because a lawyer who comes in August, we don't know whether in August the Chief Justice will not another bar bench in August, and so I will miss that hearing. So I have attempted to become the most bad person who has refused to give dates as gifts. I have resisted, and I think it has worked. Lawyers have hated me. I do not have a hearing date beyond the month of March. Those who are quarreling, I tell them, let me first finish this March, I will deal with you in April. Now, the challenge comes because you can't predict where you'll be in May. You can't predict where you'll be in April. But now, what I wanted to report to the bar is that when I give you my date, which I treasure dearly, and you come, you are for the plaintiff, you have requested for the date, and you are coming to tell me, my lord, my witness has been denied a visa of entry. What are you doing to me? My lord, this morning I laughed. Counsel for the plaintiff who applied for the date, because I fix cases inter parties, and I've also been blacklisted for doing that, but I do it for a purpose. Both parties must appear before I can give you a date. So the counsel for the plaintiff turns up, say, my lord, we fixed this case erroneously because it is practice for directions have not. So we want an adjournment. So would I be wrong to give you a date next year? Of course. So we're appealing to to understand us in the land division, that when we refuse to give you dates, it's not because we don't want to work. It's because we want to give you dates which are predictable, dates which will find us seated on our desks, dates which are for real business, not dates for mention. I will report in this gathering that in my diary, I don't have mention dates.
Thank you very much.
And they don't appear.
Thank you very much.
And I can also mention, now that it is a bar bench, that if you came to my court and you are demanding for a judgment as old as 2 weeks, put up your hand. It is not there. Yes, you hear, finish, write judgment, and people go. There is no litigant who has a judgment in my court beyond 2 weeks. It's not there.
Thank you, my lord.
But you see, the lawyers are giving us a bad name. That's why I wanted to speak. Every lawyer comes stampeding on a judge. I want a date. A judge who does not give a date is a judge who is not working. It is not true. The judges in the land division, if you want to witness, just pass in the corridors. I enter my chambers at around 7 every day, but I'm shocked that when I move around by 8, their lordships are hearing cases. They are hearing cases. The whole corridor is full. And my lord, also let me report that the land division does not have the complaint of 100 judgments to rate. They don't exist in the land division. I rest my case.
Thank you very much. Let us hear from the last one from the industrial court.
Thank you very much, Your
Thank you,
Worship.
madam.
My Lord, the Honorable, the Chief Justice, unlike my colleague, the previous speaker, the industrial court has only 2 judges. And our docket is over 1,400 cases per judge, with registration of over 700 cases per annum. We have been trying to work out means of dealing with this backlog, and we used some digital mechanism that established that in order for us to complete the workload between the 2 of us, we will take 6.5 years. The court has a structure of 5 judges. So we need, that is with a recent amendment. If we got the 3 judges recruited, we would be able to cover this workload within 2 years and 3 months. That's the calculation we have done using the kind of system that we operate. Unlike other judges, we don't fix cases on a daily basis. We have been using the pre-session method of first in, first out. We have been trying to clear a backlog of the cases that were handed down to us from the High Court, which are as old as 2012 cases, which are registered in our court as 2014, because the court started hearing cases in November 2014. That notwithstanding, we are some of the judges that have over 100 cases of backlog. And we have also tried to establish why, and the reason is that we also hear cases on a daily basis. And as a result, whenever you complete the hearing, that's a pending judgment. We are supposed to benchmark His Lordship's chambers to find out how we can deny ready litigants hearing dates. And yes, because that is the only way we can stall the growth of the backlog in the industrial court. So our appeal to you, my Lord, which appeal we have made also through the Attorney General, is to assist with the recruitment of the 3 judges so that we can at least reduce the caseload per judge. And we are happy to note that at least Parliament has recently approved and agreed to appropriate some funds for the industrial court. We hope that this can be expedited so that the 3 judges are recruited, and in future maybe more are considered as part of the structure of recruiting judges of the industrial court. Because as I have said, the majority of Ugandans are potential clients of the industrial court, especially working Ugandans. And with the recent initiatives in the Law Reform Commission, the workforce is going to be even bigger because there is a move to formalize, to bring the informal sector on board, and that is going to increase the workload for this court. So we pray that at least the 3 judges are recruited within the next financial year. Thank you very much.
Thank you very much, my Lord. And let us give a hand clap for all the other contributors. It has been a very nice discussion. My Lord, the Honorable Chief Justice, those are the comments and concerns from the bar, and there is some responses from the bench. We are humbled that Judicial Service Commission equally gave us an input on some of those critical issues. I would like to thank Mr. Mjisha for having not forgotten in bullet 8, when you were raising your concerns, we thought you were only coming to complain about the courts. But when you say even ethical conduct of legal practitioners was one of the concerns, that was a very good input. My Lord, those were some of the things that you could respond to. I would like at this moment to request the President, Uganda Law Society, to respond to some of the issues that follow within his docket. Your Excellency, you may have the comfort of using your mic, or if you will, you may come here. Thank you.
Thank you, Your Worship. But I think let me just. Okay. Thank you, moderator. First, I want to take this opportunity again to applaud the Chief Justice and the team from the judiciary for coming to this forum. I believe it has been worthwhile, members of the Uganda Law Society. I also want to appreciate the Land Attorney General for coming and sharing his thoughts on the issues that we have. So I want us also to applaud him. I also want to take the opportunity to appreciate the fact that we have 3 attorney generals in the room. We have 3 attorney generals in the room. I think this only shows the power of the binding nature of Uganda Law Society. The bar and the bench can work together, and I think that we can resolve our issues peacefully and using advice from even an attorney general who has had 63 years at the bar. Allow me ask you to applaud him for being here. Thank you so much for coming. One of the issues that has been raised was the issue of a matrix, and I just want the Secretariat team to put a matrix up here so that we can all actually see that there's actually a matrix. So what we have done is we are combining the issues that we had during the bar bench forum that we had with the principal judge, and we are adding the issues. So you can see that we actually have a matrix here. Response from the bench, we have over, can you scroll down? Can you scroll down to the last? So as you can see, we have 61 issues so far. 61 issues so far. And so we have been compiling. I think by the end of today, we may reach about 80. So what we are going to do is we will share this matrix so that we have the responses that have been shared here, and then have a session to follow up on the implementation of these issues that have been raised. I just wanted to comfort members of the bar who are here that we actually have a matrix as Uganda Law Society, and we are taking this seriously. So I also want to appreciate our senior members of the bar who are here and past presidents. You know, one of the things that you see on our WhatsApp groups is that the Law Society has chased away senior members of the bar. My Lord, no, we haven't. As the Law Society, we are very intentional about having our senior members of the bar and including our past presidents active in everything that we do. In fact, my Lord, in a discussion that we had, and I think we will follow it through, having a conversation between the Chief Justice and senior members of the bar. I would just like to inform the members of the Uganda Law Society that the Chief Justice has also promised to host senior members of the bar, again for another engagement. My Lord, we will add some young members of the bar so that they can learn how to interact with the Chief Justice. That is my only appeal to you. So that will again be a further engagement. On the issue of a committee that has been cited here, we have a Judicial Affairs Committee, and what we are going to do now from the responses here is we are going to be able to strengthen that committee with more members from the senior bar so that we can have an engagement which is not based on a quarterly basis, but perhaps on a biannual basis, so that we keep meeting with the judiciary so that we can be able to solve these issues. I think on my part, those are the issues that have been raised. I think lastly, I wanted to speak to Justice Kiriabuire's point on dispute resolution. I think that it's very fundamental. I think as members of the bar, we see ourselves as litigation lawyers. And I think we need to move from the perspective of litigation to dispute resolution. And dispute resolution means that it doesn't have to be adversarial. We can always find ways of resolving these issues. My Lord, the Chief Justice, we've done an analysis as Uganda Law Society. The number of cases filed annually is increasing at 30% every year. That is the number. That is the statistical number. 30% every year. So if the number of cases is increasing at 30% every year, it may not matter how many judges you employ. We simply just can't deal with the backlog unless we look at alternative means like dispute resolution. So I'd like to encourage our members, let's focus on dispute resolution. and alternative dispute resolution. Hopefully we shall be able to deal with the numbers. So thank you so much. I think those are the comments on our side, and I think this may be my last opportunity to speak. I would just like to say that this lunch, the Uganda Law Society is hosting the bench to a lunch after this session. Yeah. Sponsored by the Attorney General. Anyway, that's on a light note, sponsored by the Uganda Law Society. The Uganda Law Society will host the Chief Justice and the judiciary to a lunch, together with the members who are here physically. So if you came physically, that is the opportunity you have had. So thank you so much. Let me also thank all those who are online. Thank you so much for participating. My Lord and members, we have over 1,500 members online. So there is clearly no boycott. There is no boycott. We have over 1,500 members online. And I want to be very clear to our members, our view as the Executive Council is engagement. We believe that we can constructively engage on all issues and have solutions and move the society forward. As a leader, my role is not to create disunity. My role is to create harmony. And therefore, as the Executive Council of the Law Society, and my Lord, the Honorable Justice, and to the judiciary, this is our stand as the Executive Council of the Uganda Law Society. We must lead. Yes, we lead through crisis, but we lead by uniting people. We don't lead by separating people, and we will continue to do that. So thank you again, and thank you so much.
Thank you very much, President, Uganda Law Society. And we want to thank you for the lunch, but we also wish to declare it will not influence our decisions because we are an independent judiciary without fear or favor. My Lord, Honorable Chief Justice, allow me to invite the Honorable Attorney General to make his wrap-up, and shall invite you after. Thank you.
Thank you very much. This has actually been interesting, but actually it's good that the metrics has been shown. Because I want to start by saying to Mr. Mutabingwa, we speak good English, but we actually act. From the last forum, we increased the number of judges through amendment in the Court of Appeal. As a result of the last forum, the Honorable Chief Justice has increased the circuits of High Court. From the last fora, we have been discussing the Judiciary Council, the issue raised by Honorable Justice Madrama on the issue of the jurisdiction of magistrates. From the last fora, we have increased the circuit of Chief Magistrates. So we speak English, but trust me, we act. And therefore, we call upon the Uganda Law Society, whether we have acted on only one issue, let it be said that we did this year only one issue. But I know that with these things that are said here are taken very seriously, and your president is also not an easy person because he sends you the metrics every like 3 months. And I say, why are you sending me the metrics? You can read it and tell me what I'm supposed to do. On the issue of court judgments, yes, the issue of court orders, I am constantly writing letters on the issue of respect of court orders. But I also get a lot of information and feedback from the institution on misuse of court orders by lawyers. Now, we are stuck between a rock and a hard place. If you let it go and just say witness, when damage is done, who is responsible for what is supposed to be done there? If the court says that you are supposed to go and evict a person, and you go and take their property, what do we do? So it's that, but we'll continue engaging and trying to find ways of balancing out the two. For example, just yesterday, not yesterday, the other day, Justice Wamala wrote a decision about the Judicial Service Commission and the appointment of representatives of the Judicial Service Commission. A member of the bar wrote his interpretation of that judgment and said that the members of the Judicial Service Commission must leave. Now. So now you have created a paralysis in the Judicial Service Commission. You're asking us for judges. You have created a paralysis in the Judicial Service Commission because now I have to sit and write an opinion to say, no, when the judge wrote the judgment, he did not say leave now. That takes me a whole 2-3 days from the time I get the complaint from Judicial Service Commission. But trust me, all the work that was supposed to be done in this week has not been done because of that. But when we come back to the next bar bench forum, you're going to blame us for actions not taken by the Judicial Service Commission. So this shared responsibility, and I think what Honorable Ruhindi said is extremely important. What we do may seem like a simple action on your part. It is, as far as you're concerned, you have met your ends, but has far-reaching implications. So 1 week of judicial service work has stopped, because they have said until you render an opinion on whether this is the correct thing, we will not move. But I know that the lawyer who read that judgment knew what the judge said, because it was so clear. But that is what it is. So I won't say anything about cyberbullying. I think we've said a lot about it. We just need to protect each other. If you attack a judge, Chief Justice said he will attack back, but how many will? Our colleague there said, when you attack the judge, you say the judge is corrupt. Judiciary is corrupt. You haven't said the judge. Judicial Service Commission doesn't have a complaint. The public hears a lawyer who is part of the profession saying the judiciary is corrupt. That is a problem. So we just need to be responsible in how we communicate these things in the public. The appointment of judicial officers, what you talk about is something we hear the same way we hear it. They're incompetent. You ask them who, will tell you in camera, Mr. Kanduho, I am here and you are on record that you are going to bring that complaint in camera to the Judicial Service Commission to handle. So that when we come back next time, we tell you what we did about it. But more importantly, we at the Judicial Service Commission did realize our shortfall, our challenges. What did we do? We went to the Constitution, read it, interpreted it, and said, since we are recruiting too many judicial officers, why don't we ask them to be appointed in acting capacity so that we can get an opportunity for the public to vet their competence? Because you know the moment a person becomes a full-time, now, who sued me? Uganda Law Society. We are happy to give you a judge on full-time till death do you part. But we must tell you that we will do the work within the capacity of the Judicial Service Commission. We are incapable in the structure that we have now to check and vet 161 applicants for judicial positions of 11 judges. We received 161 applications of complying advocates for those 11 jobs. So that's the reality. That's what we are dealing with. So we try to innovate to try and get this working. And so we are hoping that I will not comment on the issue of the bail. That is a matter that I think we should not allow ourselves to interfere with the discretion of the judges. If you think the judge has given a high bail condition, appeal it. So let's go and appeal it and explain to the next judge that this is not good. This forum, that's why I was saying earlier, which forum are we using to raise what issues? Because now tomorrow the people will come here to discuss the issue of whether we should cancel titles. And that takes me to the issue of succession. Yes, I did right, but I will not say much about it. The issue was the law under which the succession registers were given expired. It was repealed in 2000. That's the position. So that was the simple position of the law, and the second position is limitation. However, I will not go into the great length of explaining this because, fortunately, one good person, Lufunya Derrick, has filed a constitutional petition in the Constitutional Court which gives us an opportunity to go to the Constitutional Court to tell them that the law was repealed. And we shall argue the case and then the decision will be made. But I am happy, colleagues, like I said, I don't need a judge to convince me I am wrong. I don't need the Constitutional Court to convince me that I am wrong. By the time I wrote that opinion, I have thought about it, but I could be wrong. Now, if this person had come with all these arguments that they want to bring in the Constitutional Court, maybe I would have sat with him and said, this is my view. Then he sits with me and says, this is my view. And then we agree either I withdraw the opinion and render another one, or he goes to court fully aware of my thinking, because that's how we work. And the lawyers who know how I work, you have a matter before you file the suit. Actually, I call someone and say, why are you filing? I'm not going to defend this matter. There were two titles, one was put over another. I tell the Commission of Law, I'm not defending that matter. And I've gone to court and told the judge, please remove the Attorney General from this matter and add this registrar. Because there was a title and he put another title on top of it. Do I need a judge to tell me that that's wrong? Must I go to court to make a decision that that is wrong? So that is where you need to come in. If you realize that something is not right, bring it, let's discuss it. You can sue the Attorney General as many times as you wish, but the only problem is you're taking away the work, the time of the judges from more important matters which should help the society. Yet your matter could be resolved. I know someone told me once that the reason they sue is that if we settle, we don't get costs. So I told him, but if you have resolved the dispute of your client, why doesn't your client pay you? Says, no, but the client's pay is smaller, we can get more in costs. So I said, really? That becomes a problem. I have not come to court since I've been to office on a dispute on ranches. And that takes me to where Justice Chiriabwire is. We are using more the method of opinions, rendering opinions to government. You look at a case you have lost severally. I came into the Attorney General's chambers, we had lost 81 cases on DAPCB properties, which were costing government 133 billion shillings in damages and costs. That's the bill we have. So I said, no, this can't work, because if the first judge and the second judge and the third judge and the fourth judge have all ruled against us, what is the chance that the 20th will rule otherwise? So we rendered an opinion to government and said to government, no, as long as a property was repossessed, and Honorable Ruhindi had written a similar opinion a few years ago, as long as a property has been issued with a repossession certificate, DAPCB has no jurisdiction. That was it. So now for me, when they sue Attorney General on that matter, my defense is very simple. There is no defense. I agree with the plaintiff's claim, and I'm asking the court to give judgment. So DAPCB complained that I am compromising their case. I have told you, I've written. I am not going to change my opinion in a defense. So I wrote 3 defenses, the case is stopped. I wrote to the court and said, yes, WSD, the Attorney General accepts the claim as given by the plaintiff because this is the position of the law, and attached is the opinion rendered. Finished. So we can resolve these matters and help the courts to resolve these disputes amongst ourselves. On evidence of corruption, Honorable Mutabingwa, this is not, the example you gave is not good. Because that's a private matter. This is a public matter. If you tell me that a judicial officer is corrupt, for you to say it in any fora, you must have evidence. That is why the process of dealing with judicial officers is through the Judicial Service Commission. When you file a complaint there, and we find it has no merit, you don't get it in the public. You're not going to find a judicial officer in the public being lambasted for being corrupt, and then you think that the public will go back before that judicial officer and expect them to get justice. No. Let us set a standard. Either we suffer locally, as we used to say at campus, and we swallow it, or we get up and deal with the problem. and we must address it. Madam Chirunji, yes, my method is a bit combative. Actually, it's changed. It's changed over the years because now I've even learned to keep quiet. When I first joined the Attorney General's chambers, when you had abused me on Twitter, I'll go there and deal with you also. You go and make the argument on Twitter, I make it there. But with time, I've even calmed down, and now I let you just do it there. But when I get a fora like this one, where we have created the fora for ourselves to deal with the problem, I want to tell it to you as I believe it is. Because for me to try and be politically correct is doing us a disservice. But I would really like to thank the Law Society and Honorable Ruhindi and Honorable Godfrey Rule. Thank you very much for your words of wisdom. At times we actually need people to temper us a little, to guide us on these things. But like the President Law Society said, dialogue. By the way, for members of the Uganda Law Society who don't know, there is no action that I have taken publicly which I have not discussed privately, severally. And the President is here. Even when I filed a suit on the issue of the judicial officer, I spent 2 days, and I even requested that I needed to meet those people who are petitioners, to request them to withdraw that petition for the EGN. So whenever you see me acting in public, you need to ask the Law Society, what has the Attorney General, how far has he gone? I bend backwards to try and keep things under wraps. So by the time I act, I'm exhausted. I don't know what else to do. But now that we have these forums that are coming in, we shall continue engaging. And please, when I am wrong, I beg you. And it was happening very well. People used to come to me. So please come, tell me, Attorney General, this is wrong. This is how we need to do this. This is the challenge we are having. You don't even have to wait for this forum. But let's work together, but let's protect the image of the legal profession, which has both the bar and the bench. We cannot go out and put all our dirty linen outside. We can't. We need to go back and figure out how to deal with it internally. I thank you very much. Madam, my Lord, we shall raise your matter with the Minister of Justice, or rather Minister of Gender, Labor and Social Development. I was just quipping to the Chief Justice that if I had been Attorney General at the time your industrial court was set up, I would have insisted that it remains in the judiciary. And I think that's where our distortions are. Because as we struggle to deal with the judiciary issues, we have now another parallel system which is feeding into the judiciary, which is outside in courts of the judiciary. So we really need to think about resolving that issue. I know it has these issues, but we need to seriously think about where your home should be, which I think should be back in the judiciary. Because this judiciary is supposed to handle all matters. All matters. So the structure of the industrial court could remain as it is, but who is servicing you? Because we struggle. When we are dealing with judiciary issues, they are not the policy issues we can deal with of the industrial court. So we talk about the industrial court, but it has another policy holder. So while we talk about, so when we do the amendment of the Judiciary Act, it doesn't affect the industrial court. When we do structures of the judiciary, they don't affect the industrial court, which we know is a part of this entire judicial system. So we need to think about it, but I'm going to raise it. I promise. And the issues you have sent me to raise, I have raised, and they have all been handled. But we hope that one day you will become directly part of us. So thank you very much, everyone. Senior counsel is present. Thank you for all the calls you make to me when issues come up, and you help me to remain sober at times. So when those messages you send me and say, no, just ignore that, are very helpful, and I encourage you to continue doing that. Thank you very much. I'm still learning. Now it's again my singular honor my Lord, the Honorable the Chief Justice, to invite you to make your remarks, which will also be the closing remarks of this event. Thank you.
Thank you, Honorable Attorney General. Let me reiterate the point that I'm greatly impressed. I think we've made a milestone in having this discourse, in having the Uganda Law Society sit down together with the judiciary, speak candidly about the issues that affect both of us, because we are all sworn to ensure that the rule of law prevails in this country and that our people are governed under democratic dispensation. I'll respond to a few of the issues raised. Many of them have been responded to. Let me explain a little bit more about the letter by the president that generated the response from the Uganda Law Society, which we say was the right thing was done wrongly. The concern was right, but the method of doing it, in our view, was wrong. And but is given rise to this setting of today. The letter in which he requested me to look into that issue, which any of you could have written. You could have been a complainant and you would have written to the Chief Justice, I am a counsel in this case, I'm requesting you to look into it. Many of you write, many of you come to my chambers. I suppose even my predecessors experienced the same. To me, is what the president did. He didn't say, I'm directing you, but let me explain to you what happened. There was a judgment against the Muslim Supreme Council. And then when it came to the issue of execution, counsel for the decree holder made an application for execution, listed the properties that could be attached in this execution. This was approved, and then there is something in our law which we need to revisit. That council may, the court may of its own volition, but council may also now identify a bailiff and then prepare for court's approval a warrant. I think that we are going to revisit that one. In that one, in this particular case, counsel acted fraudulently, and I'm using the word fraudulently, deliberately and consciously. Now, the list of items that they had identified in the application for execution was altered to include 2 which were not in the application. And then, of course, my judicial officers did not exercise due diligence. Now, the other problem with the mode of execution is that one does not mention this property, this land, the land comprising this leasehold or freehold or milo contains this property. It does not provide like that. You just identify the land, and until you carry out further inspection, you may not know what is on the land. Now, the mosque, the land on which the mosque sits on the Old Kampala Hill, was not in the application for execution, but was now smuggled in the warrant which was prepared by counsel. And the poor registrar did not exercise due diligence to say, why are you bringing this? I did not approve of this. Why am I saying this? If counsel had acted professionally, we would not be discussing what you claim to be the president's interference. So the root cause of this was actually foul play by a member of our society. These are things which, if we act ethically, we can avoid, we can avert. We will not even be discussing this, we'll be discussing other things. But of course, we are now wiser. Among the things we need to work on is when you identify land, you also explain what is on that land. When you identify whatever it is, you give further and better particulars of what you are seeking court to attach. And please, let us act responsibly. Let us act responsibly. We rely on you because, as I said at the beginning, you are officers of the court. So when an officer of the court comes to me with this information, I have no reason to doubt. Let's not make the courts now behave like a naked bird in a Cheve's book. Because you shoot without missing, now we have to be flying without patching. Let's have confidence. Let's have trust among ourselves that, if there was a time, I think it was Henry Kayonde again, I hope he was the one, appeared in court and cited an authority. Say, where can you avail us a copy? He said, trust me, my lord. You see? By the time you say, trust me, my lord, and I believe you, we have to reach a situation where you know that every member of the Ugandan Law Society is above reproach. But if we have where people cite authorities, reported cases, and alter the meaning. If you rely on the authority as presented by counsel, you can actually do injustice. So we normally read this authority from the original source, not this one you photocopied and brought us, because anything can happen. That is how sad it is. We have to read from the original source and get the meaning you attribute to that decision. On ECMIS, yes, but we are moving cautiously. This is something new. We don't want a situation where we roll out to the entire country and instead we occasion miscarriage of justice instead of promoting justice. So we are learning. We have expanded a little from the original pilot scheme. We want to learn from the piloting. Certainly, our purpose is to roll it out, and it benefits the people of Uganda. Court orders. Now you're addressing the victim. I have issued orders. Somebody else interferes. Can't blame me. Bring an action. I will pronounce myself as the judiciary. Come before me and say, no, this is unconstitutional. This is this and that. I'll pronounce. The Attorney General has told you what he does. I will pronounce myself. Probably will say, no, let's not even contest this. Let's find another solution. Withdraw this because we're going to find a solution. But otherwise, as judiciary, I cannot go out there and say, why are you interfering with my judgment? No. We are always at the receiving end. You must activate us, and then we do the needful. From the presentation of JMM, Senior Counsel, John Mary Mugisha, I'm used to call him JMM. I told you we grew up together, and let's get something clear. There is the constitutional responsibility of the Chief Justice, the one of the Deputy Chief Justice, and the one of the Principal Judge, and the one of the Chief Registrar. All those administer their responsibility on behalf of the Chief Justice. That's what the Constitution says. There can never, ever, absolutely nothing, no conflict between the Principal Judge in the exercise of his administrative powers and the head of a division, which is not even mentioned in any law, by the way. It is just a creation for good management. I mean, we got to abandon this notion that a file before a judge cannot be called by the Principal Judge, by the Chief Justice, by the Deputy Chief Justice, or for the magistrates by the Chief Registrar. We are introducing something very dangerous. What the Principal Judge, the Chief Justice, and the others cannot do is to tell Justice Michael Elubu, where is he? Yes, I can never tell him, your decision must go this way. No. I mean, that would be criminal of me. But if there is a complaint, and we receive these complaints in writing, oh, this is what is happening. I have to call the file and look at it and advise the complainant. Many times we receive these files, we send them back to judicial officers. You find there is nothing, it is just a misunderstanding of the role of the judicial officers. But until I call that file, I would not know. So for anyone to say a head of a division can sit on a file as if their powers are at par with the one of the principal judge, please let us forget this, because it is not true, it is not right. We will continue. Indeed, in the Justice Oteng, the case cited by my Lord the Chair of JSC, one of the defenses Justice Emmanuel Oteng raised against Chief Justice Wambuzi was that he was interfering with his judicial work. He was very strong on that. The tribunal said no. There is no independence in how you handle a file. If there is a complaint, the Chief Justice has the right to call for that file. And if he finds you are abusing the due process, he has the right to take the file away from you. That is different from saying, please decide this way. It is there. It's a finding of a tribunal which removed one of our judges from the judiciary. So let's get it very clear. And the other arm of this is, of course, you may not like my judgments. You may actually adore the judgments of, let's say, Lady Justice Elizabeth Musoke writes better judgments than me. But for you, if I'm doing my administration work, say, for the Law Society of any of you to stand up and say, no, you're mistreating this judge. No, that's not far from shopping. In other words, you're making my administration difficult. You do not want me to rein in a judge who writes very good judgment, but there is all sorts of complaints against him or her, which my responsibility is to look into. So let's get this one very clear. We will continue to do our, but there will be no bias. We will not single out any person for persecution. The principal judge will be responsible for regular transfer of judicial officers in accordance with our policy. That one nobody can take away. It doesn't matter whether you're the best Supreme Court judge or you're the best Court of Appeal, High Court, or the best Chief Magistrate. The policy will apply equitably to everybody. My friend Kandu, I'll come to you last, because it's a good conversation you have introduced. Some of the things I didn't know, like the one of ethnicity, I didn't know you, but I'll respond to you. Mr. Mutabingwa, judgments riddled with corruption. See, I'm Chief Justice of Uganda. If I were to do some of the things you do, which has resulted in this, a good number of you would walk with your heads under your armpit. You would not walk on Kampala Road. Because some of the things lawyers do. But how do I begin calling the press? How do I begin sending Twitter? They call it what Twitter. I have one which is handled. I've never done it myself. There's a team that handles for me. I was born before some of these things, so they bother me. Let me give you one example. Talk about corruption. And I have openly said, in the lower bench, I have reason to believe there's corruption. Until recently, it was very difficult to persuade me that a judge could be corrupt. But now some of you collude with judges to practice very smart corruption. Some of you. And the judges do not do it with clients. I don't think it is easy for those people to approach. But you learned counsel, you who are officers of the court, you're the biggest culprit. Take this case. Someone who is illiterate in English or any language in Uganda comes to court, comes before you in your chambers, represent me. And for whatever reason, everything that you do from the pleadings to court appearance, you're actually not representing this person, you're representing the other side. What is that? It has happened. In our court, by lawyers, you see that the person has been compromised, the poor person does not understand, is depending on you 300%, and all that you are doing after eating their money is to work for the other side. What it means is that the other side has paid you hundreds times what this other person has paid you. And then it is you who get to judicial officers. And then you read the judgment, and in fact, Mr. Mutabingwa is right. You read the judgment, and because if I say what I want to say, you would know which case I'm referring to. I mean, a judge of the High Court will not write that judgment, will not make that type of award. Let me stop there. So for corruption to thrive, even at the level of the Court of Record, you lawyers are involved. And until you go for penance, I am a Catholic, I don't know when I last went for penance, because I talk to God direct, but until you search your soul individually, all of us search our collective souls. You, members of the bar, as officers of the court, we in the judiciary, with a huge responsibility to be above reproach, until we sit back and say, God will punish us when we go before him. You'll be promoting corruption, and we will never be able to fight it. But we really want to fight corruption. And it is incumbent on all of us to fight the monster of corruption. And believe you me, we can fight it. We've done our part. All these things I was telling you. One of the ways that corruption thrives, somebody files a case, it takes 7 years for the case to be heard. And from my village to Gulu, where there was High Court, 160 kilometers. And I have a land dispute with a peasant. Deep down my inside, I know I'm just in Elisha, Ahmadi is the concubine. The other person was called, the land grabber was called Madume of the big eyes, those of you who read that book. So for me, I am a Madume of sorts. We go to court, the case is adjourned 100 times. The poor fellow can only transport witnesses 2-3 times. After that, they will not be able to. When the case comes up for hearing on the 7th year, poor fellow is not there, or if he's there, can only come by himself and his wife. For me, I have bought all the elders in the village who come and speak for me. The poor fellow, who is the judicial officers, and if you were me, he is a litigant who has come only with his wife, and he is the other person who has brought an elder at the age of very senior counsel Lule, comes and stands up and says, no, this land belongs to the father of the Chief Justice. We don't know why this young man is disturbing him. It's all nice. So what would the judge do? Decide in favor of the person who has availed witnesses. So one of the ways of fighting that type of corruption, because corruption is not only money and what have you, is the inability of the people to access court meaningfully. And that's why we've littered the countryside with courts of law. And that's why we are creating, like in my sub-region, instead of Gulu, we have Gulu, Kitgum, and my hometown of Patongo. Now it is possible for the longest distance anybody would travel would be about 50 kilometers. Instead of 200, 160, 120. As population grows, somebody after me may create another one. In Barara, you go to, I normally call them with the old district names, they make more meaning. I call them Acholi, Ankole, East Mengo, and West Mengo. That was more meaningful. If you go to Mbarara High Court, you go to Gulu, those are the circuits notorious for the highest backlog cases, for many reasons. So one of the ways is to create as many high court circuits as possible, proximity, and then you have sufficient number of judicial officers to handle. Nobody is going to approach a magistrate or a judge if they know their case filed on the 2nd of January can be completed by 31st of December, which is where we were hoping we would reach. If you have all this in place, it is possible. We've done the mathematics. So that instead of waiting 7 years, you probably wait 18 months, you're out of the trial court. The temptation to say, I can give you a goat or some money will die. That's one of the ways of fighting corruption, alongside the need to be ethical in our judicial and legal work. And where do we get these magistrates from? Where do we get judges from? From society. It's not like there is some cancer in the judiciary which eats up the mind, the hearts of people. Angels come and they become devils in the judiciary. No. If we have this, we're talking about a general malaise. We're talking about a general issue of corruption in this country. So we must not speak about the judiciary in exclusion. We must talk about where we are as a country. How best can we fight corruption? The cancer, the biggest cancer in this country is corruption. How do we fight it? If you single out the judiciary, it's like jiggers. When we are young, for you children of the rich, you didn't experience jiggers. Some of us did when we were looking after goats. You must remove the jigger itself. Now I don't see jiggers in my area. Remove the jiggers from your foot. You cannot plaster it and say you have dealt with it. No. So let's as a country, let's talk about this. And then what my brother Justice, we call them Justice K, because our lecturers in the alternative dispute resolution class, they are difficult in pronouncing Kiriabwire. So it's now notoriously Justice K. Let us, as members of the legal profession, embrace alternative dispute resolution as a robust innovation, robust intervention in dispute resolution in this country. United States is the biggest economy in the world. Of all disputes in the United States, 98 or something percent is resolved outside courts of law. 98% is resolved through alternative dispute resolution, arbitration, mediation, conciliation. That's where the lawyers are doing business, brisk business. So let nobody deceive you that the introduction of ADR takes away business from you. No. Actually, the turnover will be better because 2 months, 1 week or something, you've sorted out something, you're into the next case. So when you look at the turnover, you're much better off. There are even criminal matters. Of all the criminal matters that are determined, about 95 or 96 are done by alternative dispute resolution. You agree and somebody pays, I don't know how they call them, let me not cause diplomatic row. So let's embrace, because then you are going to have lesser and lesser court. As many of you, some of you already know, I've already cut out for myself what I'm going to do when I retire in 2 years' time. I'm not going to be in your Kampala. Actually, you'll need a bulldozer to bring me here. I'm going to be with the population. I'm setting up an alternative dispute resolution center in Gulu, and that's what I'll be doing with the population. Because the people of Uganda have been good, they'll still continue to, for as long as I live, They'll continue to pay me the salary I earned when I'm serving as a Chief Justice, even when I've retired. So because of that, I'm going, and I hope the Lord will allow to transform dispute resolution in the countryside where the real disputes are. That will be my contribution to society. Otherwise, I also want to thank Senior Counsel Lule. I had not realized you were here, but when you stood up, I don't know how many people, how many of you, at least the ones who are senior, fairly senior, how many of you look him up just to have a chat with him? And what he's telling us here, in those 3 minutes he spoke, in all you do, what is the national interest? In all you do, the letter of the law is not dead. That's why we say superior to the letter of the law is the spirit of the law. What is the spirit of the law? Superior to legality is legitimacy. What is legitimate and what is legal? Otherwise you just be a zombie. A zombie can walk, can even walk in the right direction, but it will be meaningless. So thank you so much for what you've said. So please find time, have a chat with him. Professor Sempegwa is here. Just take off time, go and have a chat with him. My good friend, Senior Counsel, the serving president of Uganda Law Society, you have a host, a corpus of former presidents of Uganda Law Society. As you like to think, you would consult them from time to time. They would tell you their experience, they would tell you, we did this way, and so on and so forth. We do not appreciate the importance of mentoring. Because if we did, probably today would be another day. We will not be talking today under this urgency to avert something. We would be talking as a matter of course. So I want to thank Senior Counsel Lule, Senior Counsel Ruinde. Really thank you so much that in a meeting like this, you found time to come and join us. Now, the other information I would like to give, I just want you to know. We have the bar bench, court users committees, and district coordination committees, which have been institutionalized now in the judiciary under the regulations on committees that were recently gazetted. I recently gazetted. I hope normally you pick interest in these gazettes. Your law firm should be receiving gazettes all the time, as a matter of course. We've done our part, look at it. You may even have some views. Normally before the Chief Justice appends his signature, there is some consultation. But you may come up with something that is really good, and then this can be amended. On the issue of enhancement of jurisdiction of magistrates' courts, we're working on it. We're working on it. There was a time we came up with some figure, I will not tell you, and then if we had done that, Arua High Court would have only, 12 or 13 cases remaining before it. So we're still in the kitchen, but the food will be produced on the table and we partake of it. We are working on establishing a judgment review committee for quality assurance. It's work in progress. As I told you earlier, and I've said it elsewhere, I'm very clear in my mind. The court of law is not a court of statistics. It's a court of justice. I can churn out 100 judgments, which you'll never cite. I should ask myself, how come my judgments are not being cited? Either it is so pedestrian, or whatever it is. I mean, you say nothing new. In the Court of Appeal, there must be jurisprudence coming out of the Court of Appeal. By the way, if I had my way, and for this country we had 56 appellate Court of Appeal justices sprung all over the country, we have created 8 circuits. If I had my way, the Court of Appeal would effectively be the last court. The ones in the Supreme Court would be, and as a chief, I would be fighting to sit in the Court of Appeal instead. Because if the Court of Appeal puts their mind into a case, as all the time is not being intimidated by a pile of judgments up to the ceiling, does all the research and comes up with an authoritative decision, there would be no need for appeal to the Supreme Court. And as a good lawyer, you look at your client and say, the court has decided on this, I'm not filing a case in court, let's go and talk with the other side. Or you lose in the High Court, you say, no, even if we go to the Court of Appeal, we're wasting time. Then you know the Court of Appeal is being effective. Now the Court of Appeal is like a trial court. Ask my brothers and sisters in the Court of Appeal. All that we are giving them is pressure. I don't think anybody joins the judiciary to die. No. And I tell my lords and magistrates, so you've not joined the judiciary to die. You've joined to serve. You can only do so much. Do that so much. Don't be intimidated to be unreasonable, to do the unthinkable, because you leave this place and the people who are putting pressure on you, nobody will remember you. Maybe a couple will come and lay a wreath on your coffin. So please, work hard, do only so much, but let it be a decision well considered, because what is a judgment or a ruling? The definition is a reasoned opinion of a judicial officer, but not to just write and say, I've churned out 50 judgments. No, but of course, that's not to say you come out with only 2 judgments because you want to be Mr. Perfect. Yeah. Then, as a way of fighting corruption, fighting incompetence, which my Lord Chair has talked about, we are bolstering the Inspectorate of the Judiciary. It used to be a Kampala affair. Now we are going to regionalize, or the other language they talk about is what? Decentralization. We are going to decentralize. We are going to give strong powers to a chief magistrate over the grade 1s in their jurisdiction. There could be 2, it could only be 1 grade 1, but there must be supervision. And then there must be supervision from the region. Then comes to the center. I've always used this expression. Every judicial officer, including the Chief Justice, must feel that somebody is breathing on their neck from behind. You can feel the breeze. That when you make your move, somebody is seeing, or somebody will follow, you'll be held to account. That way, we will fight corruption, we will fight incompetence, we will fight those who do not dedicate themselves. I told the magistrates, many of you, you work Tuesdays to Thursdays, excuse me, Tuesdays to Thursdays. Friday you go away, Monday you are returning. We'll begin calling you at random. Oh my Lord, I am in my chambers. I say, I'm switching off this call to WhatsApp call, and it will be a video call. Yes. Oh, I don't have. Okay, I'm sending you now. Don't go to buy. I'm sending you, and indeed I'll send you. Then I call you when you don't have sufficient time to play games, and then they say, "My Lord, I'm sorry, I'm not at the station. I had this problem." I say, "That's the next lie you announce. Just tell me you're not at the station for no proper reason. So these are some of the things we'll do. And we will come up with, what do they call it? What is it called? They do it in elections. When you voted, what is it called? No, where you... Biometric. Thank you, my lord. We are getting there. So I'm just telling you that some of the things, it will be there because we've tried with registers. The person who is in charge of the register will keep the register. Those who have come early will not sign until he or she who comes at 11 first signs that they were there at 8:30. Then the others can now sign. We know about all this. But when we go to biometric, and we hope we'll reach there. You cannot lie. You cannot come at 11 and say you arrived at 8:30. Because it will say, no, you did not arrive at that time. So these are some of the things we are doing to ensure that the judiciary lives up to the promise, to the expectation the people who own judicial power have given us. Please help us to achieve this. You as officers of the court, let's act together in concert. Let us act in harmony. It doesn't remove your right to talk about the things that are not going right. But as I think the Attorney General said, in society there are dirty linens. Let's wash them where we can wash them, but not out there in the open. Now let me get back to my friend. I don't remember, I didn't know, I know you very well, but I didn't know the other post was by you. I remember I read in passing this one where you say, your source was also my source. The reason I picked interest was this was a lawyer saying, acting on hearsay. I think I should also blame myself for acting on hearsay, and but I was concerned, but because I thought a lawyer would do better. The Balalo thing, the first time I had somebody refer to ethnicity was a member of parliament from Kazo or something like that. I don't know if you come from Kazo yourself. Are you also a Mulalo? You are a Mulalo. Is the reference to Mulalo an ethnic? Is because I was I made the 1995 constitution. I don't remember a tribal ethnic group called Balalo in this country. Yeah. So you have introduced ethnicity, that's why I'm responding. And I'm doing it in very, very good state. And I know you, you know me. What surprises me, you should have walked to my chamber and say, Chief Justice Owindolo, this is not you. You would not have written. Actually, you would have written to defend me against the Ofonopondos of this world. But as I told you, you know what Ofonopondos. He said two things very important, by the way. He said I would die in my own movie. And I almost responded, I think I will die the way Uchumi died in their own movies. If you remember him and Uchumi. Yes, because he's used to people die in those in grabbing movies. But that is just, it's not important. But what is important, Landed Council can do. Go and read Ofonopondo again. The most important thing he said was that I need to know, with regard to what they call the Balalo, that there are people in government who have prior knowledge of government policy, of government action, which is going to take place in area, and they rush to acquire land in those areas. I want this to sink. That people in government, I want this to sink in you. But otherwise, the truth is, and it is good I'm speaking about this, the president of the country, I'm sure you know who the president of the country is. You've heard of him. You have even drunk milk together with him, I'm sure. He's the one who came out with an executive order, May last year, 2023. An executive order on 3 issues. The Karimojong raid in the neighboring districts in Acholi sub-region, the massive destruction of the environment in the Acholi sub-region, and then, in his own words, the Balalu intrusion. There was not Owen Dolo who said Balalu, it is the president of the country. So if anybody is being anti some ethnic group, you blame the president of this country. It's the one who, yes, said, and he gave his reasons. I want you to read that executive order. And in the end, he said, he gave a deadline. All these people who are there must vacate. And if there are anyone who says, I acquired the land lawfully, it will be examined, established, and then once it has been established, then he gives conditions on how you can live there. And this was against a backdrop of massive destruction of properties. You know, and you want to know, by the way, my cattle keeper is a Mulalo, what you call Mulalo. Understand? So you say, if I'm passionate about Balalo, I'm passionate about them as very good cattle keepers because one is looking after my cattle. To that extent, yes. So there was another voice. Another person responded, and in these words, this order you've given is not fair. The people who are there, because the president had said, the people who are there, and I don't think the president of Uganda acts impulsively or spontaneously. He has the capacity to investigate any complaint that comes. And indeed, among the people who were trampling on people's property, crops, and the area is a crop growing area, it's not a cattle keeping area. People from Rwanda, people from Tanzania, and people from DRC. And the president states in his executive order. If you visited me, I would give you a picture of a Rwandese who was found in that area with an ID of Rwanda. So he gave this directive, and then a very senior person wrote to him. So the people who are there are actually not the Balalu you are thinking about. These are government ministers, military officers, in writing. And that is when now he delayed the implementation. I think he pushed the deadline. That's something for verification to take place. At that time, you are going to have an insurgency in the Acholi sub-region. You don't know what war is about. You've never seen war. I lived in war my adult life. I've been a leader during the war. So he is the one who involved me to cool down the temper, because there were voices to say, let's go march onto this Balalo and drive them away. And you know what would have happened. So my involvement by the president, which does not in any way conflict with this famous Bangalore thing you cite, you cite the letter but not the spirit, was to speak to the people, bring the people. He didn't want to involve politicians for this. Indeed, I brought people on the ground, took them to the State House. They spoke for themselves. Then the remark I made, which made some people now broke Alfondo Pondo to speak ill of me, was this to the president. This I can tell you. Your Excellency, it is painful. You have ministers who should help you to come up with a policy for the recovery of the war-torn people of this area. They're the ones going and grabbing land. They're the ones who are now employing Balalo to look after their cattle. You have military officers who should be promoting your revolution and now grabbing land. This is unthinkable. That one I told the president. Beyond that, I've never said anything about the Balalo. But if you had come to me, you've known this. Then we agreed with him that I would go and speak on radio, which I did in Gulu, and it was connected to all the FMs in the Acholi sub-region, that let nobody take the law into their hands, because this is a matter which is being resolved. I explained to him that a committee has been set which will do the verification. He amended as a result of those visitations, he amended, he said, okay, those who are roaming the countryside must leave. But those who claim to have fence of land, which they say they bought, can remain until a verification committee goes and verifies that the land was lawfully acquired, the fencing is proper, and there is water provision, and so on and so forth. So this is what happened. If you think a Chief Justice should not do that, we will never agree with you. I have no apology to make. I would do it again until the Lord calls me. That one I would do. Because I don't want that society to see bloodshed again. For you, you've not lived in war. You can afford to play games. For me, it's not a matter of games. The Bangalore Declaration will never help our people to stop bloodshed. And by the way, if you want me to step down as Chief Justice, it is the easiest decision. You have to choose between being Chief Justice and ensuring that there is no armed conflict in Acholi sub-region. Even from here, I'll walk away and write that letter of resignation. Thank you.
Thank you, Honorable Chief Justice, for those remarks. Thank you, Honorable Attorney General, for the remarks, and thank you, the President, Law Society, for those remarks. We are out of time. Just 1 minute. Let me call upon Senior Counsel to give us the way forward and bless the meal we are going to partake. Thank you.
I have not been conferred with any powers to bless a meal. All I'll ask my learned friends and my lords, we have a QR code on your desks. If you could please complete it so that we're able to know how many of us were present. The Uganda Law Society would like to collect that data for future purposes. Once again, we want to thank you all for gracing us with your presence, for your contributions. For our colleagues online, thank you very much for being attentive, for being passionate about these issues. And we hope, my Lord, that we can engage with you in another 6 months or thereabouts, so that the issues that have been discussed here, we can continue having a dialogue. Because as you have said, my Lord, we are one body. We are not different from each other. We are one body. We all benefit from having a country that is governed peacefully, democratically, and we all benefit from the rule of law, from a society that's governed by the rule of law. The President has invited you all to lunch, so the lunch will be served at the Equator or the Renzori? At Equator, yes. And the ushers will guide us as we proceed to lunch. Thank you very much once again, and have a good afternoon. We shall close, we shall have the national anthems, and then thereafter we shall proceed to have lunch. Thank you.
Mungu twaomba unilinde Jumuiya Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tulilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu.